Okay, welcome everyone. Tonight is October 16th, 2008. This is a public hearing for the City of Lowell Zoning Board of Appeals. There are several petitions on tonight, and a lot of you may have seen the agenda. There are 3 petitions that should move relatively quickly, so I'm going to take the agenda a little bit out of order. So what I'll do is I'll read the order that I'm going to take it now, and if you have the agenda on you, maybe you want to just note where your petition will be. The first one I'm going to hear tonight, the first one the board will hear tonight, is the special permit for Rite Aid regarding the request for an internal illumination of signage. The second one is going to be a special permit for Eastern Bank, also to reface an existing sign. And the final sign application is going to be a special permit and variance for 603 Bridge Street Realty Trust. After that, we'll start and go in the order of the agenda. Number 4 being Jose Morales. Number 5 being Paul Bowden, 71 Lupine Road. Number 6 being Zen Juan, Lakeview Ave. And number 7, a special permit, Edward Ray on 10 Concord Street. So we'll start right away, and we'll ask if there is a petitioner here for ZB 2008, number 39, a special permit, Rite Aid, care of Metro Sign Awning, 11 Wood Street, located in a regional retail district. This is a petition to allow the internal illumination of signage associated with pharmacy drive-through according to section 6.3.2 of the zoning ordinance. Would a representative of Rite Aid please address the board? Good evening, sir.
Metro Sign. We're petitioning for an illuminated sign for Rite Aid. It's a low-voltage LED internal sign, internally lit sign. I believe you guys have all the paperwork for all the drawings and everything. It should fit within all the parameters of the zoning laws.
Okay, thank you, sir. And sir, this, I think this business came before the board before when it changed from, was it CVS or Brooks?
Brooks
to Rite Aid. Okay,
yeah.
just making sure it's the same place. Okay. And really, all you're asking to do is to illuminate the overhead for the drive-through?
The overhead for the drive-through, yeah.
And is that anticipated to be open at night? Is that the reason for the illumination?
Yes, that's the reason, yes.
Okay. Okay, anybody here wishing to speak in favor of this petition? In favor? Okay, hearing none, that portion of the public hearing is closed. Is anybody here wishing to speak in opposition of this petition, in opposition? And hearing none, that portion of the public hearing is closed, and now we'll open up to the board for discussion. Bill, any thoughts?
Thank you, Mr. Chairman. No questions. I think Rite Aid has done a fantastic job over there with everything they've done before us, and I fully support the petition.
Thank you. Jack?
I agree with my fellow board member. I think I have no questions. They've been before us before. They've complied, and I am in support of it. Thank you very much.
Okay. Ian Vesna?
I do concur, Mr. Chairman, with my fellow board members that they've done a good job so far, and that there's a need for the sign to be illuminated if this were to operate it at night, so I'm in favor of this as well.
Okay, and Rick?
Through you, Mr. Chairman, to the petitioner. These are just signs that are going to be refaced that are already out there, correct? It's I have no problem with that.
Yes, that's correct.
It's pre-existing out there. It's just
That's correct.
no problem. No other questions, Mr. Chairman.
Okay. If the board wishes, I'll entertain a motion.
I make a motion to approve the petition.
Second.
Roll call, please.
Approve.
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 So you've been approved unanimously. If you could just come up here and just sign and date this plan and hand it over to our clerk, Stephanie, I'd appreciate it. Thanks. Good luck. Anywhere, just date it and sign it. And you can just walk over to Stephanie right there. Yeah, just be careful, Kevin. Okay, the next petition is ZB 2008-41. That's a special permit, Eastern Bank, care of Richard Batten, 749 Lakeview Ave, This is located in a neighborhood business zone, and the petition is to reface existing internally illuminated signage for Eastern Bank according to section 6.3.4 and 6.3.7 of the city zoning ordinance. Welcome, sir.
Thank you. I'm Richard Batten from Batten Brothers Signs. I'm representing Eastern Bank. We're actually requesting to remove 2 existing Mass Bank signs and replace them with 2 Eastern Bank signs. Eastern Bank has recently merged with Mass Bank, and so we would like to replace them. The existing signs are similar, are typical sign cabinets. However, the new ones would be simply Eastern Bank internally illuminated letters placed on the facade, would not be the rectangular signs with the typical illuminated background. So just the lettering would be illuminated. The signs do conform to the size as prescribed. One would be facing Lakeview Ave. One would be facing Aiken Street, and the other one West 6th Street.
Okay, is there anything else you'd like to say, sir?
No.
Okay. Okay, anybody wishing to speak in favor of this petition? In favor? Hearing none, that portion of the public hearing is closed. Anybody here wishing to speak in opposition? In opposition? And hearing none, that portion of the public hearing is closed. And now we'll open up to the board for discussion. Bill?
Thank you, Mr. Chairman. I really have no questions, and I fully support the petitioner's request.
Thank you. And Jack?
Through you, Mr. Chairman, again, I agree with Bill. I have no questions except one comment. I'd like to welcome Eastern Bank to the Merrimack Valley and wish them success. Thank you very much.
And Vesna?
I have no question, Mr. Chairman.
Okay, and Rick?
No questions at this time, Mr. Chairman.
Okay, entertain a motion.
Motion to approve.
Second.
Roll call, please. Stephanie?
Approve.
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 Okay, sir, you've been approved unanimously. If you could just come up here and sign a document and hand it to Stephanie, I'd appreciate it. Thank you.
Sure.
That's not your fault. That happens all the time. Okay, the next petition is ZB 2008-42, special permit and variance for sign 603 Bridge Street Realty Trust, Wendy Lay and Robin Lay, 603 Bridge Street. This is in a traditional mixed-use district, and the petition is requesting to reface and internally illuminate existing signage and to maintain existing size of freestanding sign and menu reader board on top of, for Top Donut, according to section 6.3.4 and 6.3.28B of the city's zoning ordinance. Good evening,
Mr.
sir.
Chairman, members of the board, my name is Walter Chambers. I'm an attorney in Lowell. I represent the petitioners Wendy Lee and Robin Lee, trustees of 603 Bridge Street Realty Trust. They purchased the property in June of 2008. Prior to that, it was a pizza place. Before that, it was Kentucky Fried Chicken. My clients own a donut shop known as Top Donut, which is located at the corner of Aiken Avenue and the VFW Parkway. They want to open a second donut shop there. What they want to do is seek a variance for the one freestanding sign in front. It's because it's more than 30 square feet, and the reader sign is more than 30 square feet. A special permit for the signs to be internally illuminated. These signs have all been erected almost 20 years ago by Kentucky Fried Chicken. My clients desire not to enlarge the area or do anything else, just maintain existing signs.
Okay. So Walter, there's no changes to the dimension really?
There'll be no change in dimensions or anything else.
Okay,
It's what you have there, that's going to be the same. It's been
Okay.
the same for almost 20 years or more.
all right. Anybody here wishing to speak in favor of this petition? In favor? Hearing none, that portion of the, I'm sorry. Step right up.
Good evening. My name is Anne Marie Page, and I am the president of the Centerville Neighborhood Action Group. We are quite excited about Top Donut moving to Bridge Street. They're good neighbors. They keep their property neat and clean. They work very hard. They keep their windows shiny and clean. They don't have 8,000 million signs over them. And we realized that this big sign was there before they arrived, and they're trying to live with it in a nice way. We don't like signs in Centerville, but we have to live with some of them. But we do like lights. And Robin has lights, and Robin has a broom, and he knows how to use it. So we are very happy. He is a good neighbor, and we're sure he will continue to be a good neighbor, and we're very happy, wish him well, and I'm sure we can live with the sign.
Thank you, Mrs.
Thank you
Page.
very, very much.
Anybody else wishing to speak in favor of this petition? In favor? Hearing none, that portion of the public hearing is closed. Anybody here wishing to speak in opposition of this petition? In opposition? And hearing none, that portion of the public hearing is closed, and we'll open up to the board. Bill?
Thank you, Mr. Chairman. First of all, I'd like to applaud the owners of the business. I think in this day and age, with the economy the way it is, that a business can open up a second location is quite noteworthy. I know the planning board had a discussion on this, and they wanted to make sure the signage, the actual size was not being increased. I know that's been addressed. And thirdly, with the neighborhood association here strongly endorsing it, I would also strongly endorse the petitioner. Thank you.
Okay, Jack?
Through you, Mr. Chairman, I couldn't agree more. The actual business has been vacant now for quite some time, and actually is, since Kentucky Fried Chicken, gone through one or two different businesses. And to see it occupied and, as Mrs. Page addressed, and to have it be someone that we're familiar with, and who has already done a great job in the area, I think it's a welcome addition, and I support it. Thank you.
Okay, Vesna?
Thank you, Mr. Chairman. Ms. Page, I know she's very active in Centerville, and she patrolled that community well. I believe everything she said about these petitions. Moreover, I want to add as well that I know these petitioners from the involvement in the community. He's a very conscientious businessman, and that's speak to what Ms. Page is talking about, the cleanliness, the active involvement in the community. So I, too, in support of this petition.
Thanks, Vesna. Rick?
Through you, Mr. Chairman, I echo my board's recommendations. They do a great job over there. They really do. And for Anne Marie Page to stand up for these people, it's been through some tough times over there. That business from a pizza place that didn't make it. I hope Top Donut makes it over there. They do a very good job, and they're very, very good with the community. That's all I have to say, Mr. Chairman.
Okay. Okay, to entertain a motion?
I make a motion to approve the petition.
Seconded.
Roll call, please, Stephanie?
Approve?
Approve.
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 Okay, so you've been approved unanimously.
Thank you very much.
Walter, if you could come up and just sign these and hand them to Stephanie, I'd appreciate it. Good luck. Okay, there's one thing that it was brought to my attention on the next petition. It's not on the agenda, but I did get a call last week, and I approved, at least it would entertain hearing from Merrimackville. I'm not sure, you're going to have to tell us what this is about.
Merrimack, all right, it's Merrimack Real Estate Development.
Right.
My name is Attorney James Harrington, representing Merrimack Real Estate Development. This is concerning a variance that was granted almost a year ago for conversion of the former church at 725, 741, 749 Merrimack Street in Westchester Yard, El Carmen. Construction on this, as you may have noticed, has not commenced. I think the economy and housing market may give you a reason why. So what we're asking for now is that a 6-month extension to the variance is granted. The developer does have plans to, we're going before the planning board to try to, phase this in a way that will make it a little more economically feasible given the current market.
Thanks,
So-
Jim, and I don't think there's going to be a problem so much with that. I think the procedural problem we have is, I was handed the agenda now for the 27th, and I see you on that, on the agenda for the 27th. And I think the board would have no problem entertaining, voting on it tonight, except that there's a public notice issue that, you may run up against. So,
Okay.
we do have your packet in the next meeting, which is the 27th, and again, would have no problem hearing it tonight, except that,
Okay.
anybody who wanted to appeal it could, because they could say that it wasn't properly publicly notified.
That's,
So, the good news is you're pretty high up on the list for the next one,
Right.
so
all right.
I guess we'll see you on the
We'll
27th.
be back on the 27th.
All right.
Thank you.
Thanks. Okay, the next petition is ZB 2008-33. This is a request for a variance. This is Jose Morales and Brenda Santos, 90 Bayberry Drive. And again, this is a continuance from a prior hearing. This is located in a traditional single-family, and the petitioner is requesting to construct a deck with insufficient rear yard setback according to Article 5, Section 5.1 of the Table of Dimensional Requirements. Would you please address the board?
Good evening, members of the board. My name is Jose Morales. This is my wife, or future wife-to-be, Brenda Santos, presently a Lowell firefighter. I am a veteran. I work with the veterans still at the VA hospital in Boston for going on 15 years now. I've been living in Lowell for over 40 years. Graduated from Lowell High, raised 3 kids, one of them being in Afghanistan right now with the Marines. And I apologize for being here and taking some of your time, but this is enough stress with my kid being in war right now and having to deal with this mess that we're in right now. Trying to build a deck, 15 by 17. If we can cut that down, right now my distance is 25 feet from property line to where the deck is going to, property line to property line. I'm requesting 15 feet. If I can't get 15 feet, I'll be happy with 10 feet by 17, but right now I can only do like 5 feet. My neighbors around me, as I can see, I have one that's opposing what I'm requesting. They're the ones established right behind my property. I'm interested to hear what their problem is. And like I said, I love the neighborhood. When I bought the property, I was told from the people that I bought it, there was a great neighborhood. But what I'm going through right now, I wish, had I known now, back then, I'd be elsewhere. We wouldn't be in this predicament, in this mess.
Sir, can I ask you to, just at least for my purposes, just bring us up to date a little as to last time you came before the board, we granted you a continuance. Did we actually, I don't recall hearing the details of the petition. So I don't know if you had another procedural step to take care of, or?
Yes, we needed to go to the...
Ma'am, could you just state your name and address, please?
Good evening, my name is Brenda Santos. We had to go to the Conservation Department.
Okay, now I remember.
Yeah.
All right, and did you do that?
Yes, we did, and I believe I brought the package to you guys where it says that they had no problem with us building the deck. Where we want to build the deck is far enough from the wetlands which it won't create no problem or alter the wetlands.
Right, I didn't think you'd have a problem with conservation, but I remember now that you said it, that was, I didn't know if you had to go to the planning board, but I couldn't figure out why. So it was the conservation, and you've done that?
Yes.
And they have no problem with what you're doing?
No problem.
Okay. So your request here is you don't have the rear yard setback, and you want a variance to reduce the setback so you can put your deck in.
Yes.
Do you have, so you're looking to put in the best case scenario, a 15 by 17-foot deck right off the back slider?
Yes.
Correct.
Okay, so what is there now? When you walk out of your slider in the back, what do you walk into?
Stairs going down.
So you just have those makeshift stairs that walk down to your yard?
Right, got about, stairs 6 feet, and got about 5 or 6 steps going down.
Okay. All right, do you have children at home, living at home?
We have one right now, this is the only one. We used to have 3, but they've grown.
Yeah,
We just have that one little 8-year-old girl.
okay. All right, is there anything else you'd like to say?
Yeah, well, the thing is with, when we bought this property, there was a lot of dead trees and trash in the backyard, and there was no, their yard and our yard and the other neighbor's yard was all open, wide open. So, I go in there and, I improve it. And I went and I said, listen, I'm gonna put up a fence, I'm gonna clean up our yard, I'm gonna put up a fence, divide our property. And I've done that. And I've got pictures to show the before and after, how their yard looks now and how it looked back then, how our yard looks now and how it looked back then. And all I've done was improve everybody's, to live better. And I work hard, we work hard, and, all we want to do is, we mind our own business. Their problem is, I don't know, they don't like, I don't know if they don't like animals, dogs. I have 2 dogs. They're fenced in the front of the house, and we live where we live next to the highway 495. That noise don't bother. It's like music to me. The cars, the trucks going by, it's like music. I need it.
Yeah.
Right? So.
Okay, what we'll do is, if, I don't know that there's opposition, but if there is opposition, I'll give you an opportunity to respond.
Okay.
Again, to what they say. So if you want to have a seat, and I'll ask if there's anybody in favor or anybody against, and we'll deal with it then, okay?
Thank you, Chairman.
Thank you. All right, anybody here wishes to speak in favor of this petition? In favor? Hearing none, that portion of the public hearing is closed. Is anybody here wishing to speak in opposition of this petition? Please state your name and address for the record, please.
Claudia Gable.
Do you want to hand
17
something in?
Briarwood Road.
Yep, go ahead. Watch your step there.
Thank you.
Okay, welcome in. Please state your name and address for the record.
Yeah, Claudia Gable, 17 Briarwood Road. Live directly behind Mr. Morales and Ms. Santos. We're here to speak in opposition.
Ma'am, could you pull the mic down closer to you?
Sure. Thank you. We handed out some pictures here to help illustrate what the situation currently looks like. We've got several concerns regarding the deck, that if it is allowed, we feel it will adversely affect our property values, our rights, and in general enjoyment. We have concerns that it's going to obviously affect the property value. It's going to be a big difference in the general characteristics and nature of the neighborhood. And we've observed a general disregard of Mr. Morales and Ms. Santos to comply with the city's bylaws and regulations, and their apparent lack of concern for how their changes they make to their property affect the enjoyment of our property.
Ma'am, do you have any evidence of any violations they have?
Yes, I do.
Okay, are they part of this package?
I was going to talk to it, and I do have some notes in there, yes.
Okay.
So they've made at least 7 different changes to the property since they have purchased it. The first thing that they did when they moved in, they put on a farmer's porch. They did this without obtaining a proper building permit. Second thing they did, which is not in violation of anything, but as they have indicated, they went in and took down trees and vegetation. These trees and vegetations were additional buffer zone between us and Route 495. And now that they've taken it down, we've got a lot more traffic noise. We understand it's their prerogative to take down the trees. However, they took them down without any regards to where our property ended and where where theirs ended and ours began. They hired workers to take down the trees, and they were out there attempting to take down all the trees, including ours. My roommate, Jackie, here was home recovering from surgery when they were doing this. She heard the chainsaws, ran out, tried to get the folks that were cutting down the trees to stop. This was after they had cut down two of our trees, at least two of our trees. While she was standing there trying to get them to stop, they continued to cut down the tree, here again, another of our trees, and practically hit Jackie with the falling tree. So they apparent disregard for our safety as well as what is our property. When I came home from work, I went out there and saw the destruction that they had done on our side of the property line. Mr. Morales came over. We expressed our anger at the situation. He apologized, which I did appreciate. He told us he would fix the area, and by fixing the area, he had indicated he was going to bring in some additional fill to help level out the property. He would put in fill on our side of the land, regrade it, put down grass seed, and get the grass to growing and make it at least look nice. We took him at his word. We didn't want to pursue any legal actions that we could take at that point in time. The next thing he did, as he did mention, he did put up a fence. We had no problem with the fence. We felt at least at that point they would at least fence in the dog that they have that was always out unleashed and running onto our property. We figured at least at this point we wouldn't have the dog or its leftovers left on our yard. Next thing they did was come onto our side of the property and paint the fence without even asking us, did we want the fence painted or not. We didn't want the fence painted because we have another neighbor that had a fence put up and he left it natural in color. We wanted all three sides to look natural, the same coloring. So once they did this, what we did is we went and we landscaped along the fence area to try and soften the look of the fence line and to hide the two different colors of fencing. We spent several $1,000s removing grass, installing shrubs and whatnot that will eventually soften the fence line and eventually grow above the fence line and block our view because they took down some of our trees and now we've got a clearer view of them and their property.
Can I interrupt you for 1 second and ask
Sure.
a question? The fence, I'm looking at the white fence. That was a
Yes,
natural,
that-
so,
that is the one.
and your house is this house here.
Yeah.
So was it his fence or your fence?
It was his fence, but he came onto our property side of it and painted it without
Okay,
asking.
so he painted his fence, but just
Yes.
that you would have preferred to keep it that color?
Absolutely. Here again, he didn't take into consideration what it would look like from our side of the property.
Okay,
And
all right.
we
I
felt
thought you
that-
said he painted your fence, but I understand what you're saying
No,
now.
he painted his fence, which it was fine, but we would have appreciated their asking if we wanted it painted in the first place. And we felt if we're going to have a fence, same color fence all along the back of our property would have been better for our property value versus two different color fencing. So we spent several $1,000s putting up landscaping to help soften the fence line. Next thing they did was put in an above-ground pool. They did get a permit for this. And here again, had they not taken down our trees, we would not have any sight whatsoever of that pool from our yard. But since the trees have been removed, we can now see the pool and the activities to go on in the pool. The next thing they did was put up a deck beside the pool. Now this is an above-ground deck, so they already have a deck that's adjacent to the pool. And it being an above-ground pool, it is above the fence line, this deck is, so when there's people out there lounging on the chairs, not only can we see it from our yard, the neighbors across the street can also see it and have commented to us about the appearance from the street, about seeing people lounging by the pool.
Did they pull a permit for that deck?
That I do not know. I do know that they got a permit for the pool. The next thing they've done is, when they put in the pool, they put gravel and some brick down and whatnot. They didn't regrade the land, so now all this, the grading now comes over to our yard where it used to go away from the yard and towards 495. So anytime it rains now, we get rainwater coming over into our yard, which we never had before. They even have their gutter downspout directed towards where the concrete is, and that additional water flows into our backyard. And we've got a corner of our yard that is constantly flooded after a rainstorm. which it never was prior to the rain, prior to them concreting their backyard. The next thing they did was, before they put on the addition, they built a deck off the side of the house, here again without a permit. What they started out first was they put up a brick foundation, they put up enclosed half walls, which they look like wainscoting of some sort. I'm not a construction person, so I don't know. But the deck was slightly behind the trees that were there. Oftentimes then what they did was they, like most people, would use the deck. We have no problem with that. The problem we had was them doing it late at night. They would oftentimes get loud, and they had no regards to any quiet enjoyment laws or the fact that we might even be trying to sleep. A few months later, what they did is they enclosed the deck and made it an addition. Here again, they did that without pulling a proper permit. When we saw this going on, we called the town to inquire if they had the permit. We're told they did not. And our concern was we wanted to make sure that if they put on an addition, we wanted to make sure they followed all the rules and regulations. They had proper electrical in there, plumbing, and all the requirements that anybody going through an addition process should have to do. We have no problem with them putting on the addition. Several people in the neighborhood, including myself, have put on an addition, but we all went through the proper permitting process. Next thing they did was they vinyl sided the addition, which we felt was great. That should add to the value of the neighborhood, but they only vinyl sided the addition. They didn't vinyl side the original house. So you've got a house that's two different colors, and they recently put on a dog house above the bulkhead. They removed the bulkhead and put on a dog house, and that here again is a different color than the house or the addition. So we're looking at the back of our yard. We see two different colors of fence. We see three different colors of the house. We see the above ground pool, the deck on the pool. They also have a trampoline and a play set. We just feel that there is too much stuff in this yard to warrant them requesting an additional coming towards our property because they ran out of room because they put too much stuff in their yard. We don't know why they can't put the deck beside the addition or on the other side of the addition. They have a door on the other side of the addition. It is my understanding that they don't have enough setback on that side, but there are no neighbors on that side. Their neighbor is Route 495. I don't think 495 would have any problems with the deck being too close to the highway. We thank you for your time, and we hope you take our concerns into consideration.
Thank you, ma'am. Sir, if you want to respond?
Yes, I quite didn't hear everything she said, but I heard a few things. As I did this project, I never requested any money from them, any help, any labor, anything. I heard them mention dogs. To their left and to their right, they have two dogs. I have two Pomeranians, as I said. They stay in front of my yard. They're fenced in. When I first bought the house, it wasn't fenced in. Like I said, they have, and one's a Doberman Pinscher. They let them run around whenever they, the neighborhood. The neighborhood knows the Doberman Pinscher. He's a nice dog. He don't bite. And the other one, I believe, is an Irish Setter, a golden retriever. Yeah, and they're on the left and on the right. Another thing I heard him say something about the fence, the neighbor's fence. Well, their neighbor, when he put up the fence, I'm the one that put up the fence. Actually, he put the money up. He said, since you knock all these trees down and made, and you did a good job, I'll pay for the fence and you put it up. And it's exactly what I did. And that divided difference. I have pictures here, and like I said, it shows what the yard looked like and what the yard looks like now. And this should be about, about a deck, not about dogs and they mentioned the deck around the pool. I found that at the Craigslist. This married couple up in Methuen on the Craigslist. They were giving it for free, and they had the same above ground pool. It cost me $30 to rent the U-Haul truck, go get it. I didn't build that. They know I didn't build that. I mean, it was for free. If it's for free, it's for me, I guess. And the doghouse, this house was built in 94, our house, 92. That thing was rotten, holes in it, water coming in my basement. And where we're at, I know they must have paid some money because they must have water in their basement like all the other neighbors. Cost me $9,000. And that was a problem, with the bulkhead. It was rotted out with holes in it, ants coming in, all kinds of insects. And I didn't want to go through another winter with this problem.
Sir, just a question I have. Why did you, when you put the addition on the back, why did you do why is your house two different colors like that? You have the addition seems to be like a beige and your house is blue?
It's, oh yeah, the addition. I vinyl sided the addition. And I didn't have the funds to vinyl side the rest of the house. And it'll have to be done with the, hopefully next year with the taxes. Maybe what I should do is just, when I go home, that fence that I put up, I'll take it down. That's what they want.
Okay. Anything else you'd like to say?
I mean, they talk about trees. There was a tree, I got a picture of it. It was leaning like this. And they said leave it because it acts as a noise barrier. And that tree was kind of like on my side and their side, kind of like in the border. I left it. A year and a half later, it fell down. You know, like I say, I try to improvise. I mean, not improvise. Make the neighborhood better. Yep.
Hi, from what they have said, I heard something about when we were taking the trees in our property down, there were chainsaws and all that stuff, and they had surgery, and at that time, we had spoken to them. We told them what we were gonna do. We never received any complaints from them saying, my friend is injured or had surgery, stop the noise. We never heard anything like that from them. Instead, they did give us a copy of their property zone so we can know where to put the fence. But never we heard anything about stop the noise or my friend is in pain or anything like that. If it would have been like that, we would have stopped. You know what I mean? I mean, you know, they're our neighbors. And we don't have problems with any neighbor. You can, you can check all of our neighbors. They're good people. This is a family-oriented neighborhood. You know, we have problems with no one there.
Okay. Anything else?
That'll be all. And
Okay.
we did get permits for our addition and our pool and stuff like that.
So you got a permit for the doghouse shed?
For the what?
The addition on the side of the house?
Yes, we did.
The addition on the back of the
And we
house?
got electrical permits and all that stuff, and they,
What about a
Ray-
building permit? Did you get a building permit
Yeah,
for the?
building permit, yeah, Ray Costello went and inspected, and somebody else from the city went and inspected the electric work and all that stuff,
Okay.
and everything was fine.
Bob, do you have any recollection of proper permits being pulled?
No, I don't. I'd have to check the records. This application came in while I was away.
Okay, all right.
I believe it's in here.
Okay.
I don't think it's in there.
Is there anybody else here wishing to speak in opposition of this petition? In opposition? Okay, before I close the public hearing, I'm going to let the board ask any questions they may have of either the petitioner or the opposing parties, if you have any questions. If not, we'll close the public hearing and deliberate. Bill, do you have any questions?
Yeah, I guess maybe I have one or two. How much does the land slope from like the beginning of where you put your fence in to the rear of your property? Is there a dramatic slope, or is it just gradual?
A very slight slope.
Okay. And what's the height of the fence that you put up?
6 feet.
6 feet, okay.
If I need to put up a tree, if they want 2,000, 3,000, 4,000 to put up a tree for the privacy or whatever, I have no problem with that.
Yep.
I like my privacy too. I mean, I'm not. They know we don't party in our house with
Right.
there's occasions where we have birthday parties, and Christmas and but we don't ask. We don't go crazy partying and drinking and.
Well, I guess by looking at the pictures that were submitted from the neighbor, I'm trying to gauge how high of a fence would you need to totally block out everything there? I mean, the fence is up. It's a 6-foot fence.
And the
In
thing is-
hindsight, how high of a fence could you put up to totally block out the area? I'm just kind of asking the question. If I understand the neighbor's concern here is that what they have to view from their piece of property. And I'm just trying to take a look at this objectively and say, well, how high of a fence would you have to have put in? 9 feet, 10 feet, 12 feet?
Whatever needs to be taken,
Yeah.
I will do. Like I said, if I need to put up a tree,
Yep.
or trees, whatever, I will do that. I have no problem with that.
Right.
And like I said, I requested 15 feet. I don't need 15 feet. But the thing is, with 10 feet, I can, like, they did additions, and they got a nice deck. The other neighbors, they got a nice deck. He's a mailman, and he would have came here. He
Right.
wanted to write a letter. I said, no, we won't need it. Neighbors would have came, but I said, no. Let it be the way God wants it to be.
Right.
If it's for us, it's for us. And they got a nice house. They got a nice land. They keep their grass nice. And one of these days, I want my grass to look like that. But it's because they've been there living for a while. I got pictures here of what their land looked like before we moved in, and the way it looks now. Ever since we put up the fence, they got stuff hanging on the fence. And that fence, we put it a foot away, towards me, where it's not directly right on the property line.
Okay, sir. Mr. Commissioner, have you heard anything so far as the proposed construction that they want to do? Have you heard, or do you have any opinions on what they're attempting to do falls in line with the rules and regulations?
I don't at this time, and
Yep.
like I said to the chairman, I wasn't in when this application came through.
Yep.
I'd have to check about any permits that were issued or should have been issued and on any allegations that were made earlier. But no, I don't.
Okay. I don't know if I really have anything else, Mr. Chairman. To me, it seems to be an issue around, privacy and view, but I don't know how we can really deal with that one, but
Well, we can put as a board, it's within our scope of our authority to put in any reasonable conditions if we decided to grant it.
I mean, for instance, the fence went up. I understand the neighbors complain about them painting their side of the fence, but I didn't hear anything about the fence was not put up. It must be on your land. So I didn't hear anything about the location of the fence. To me, just based on the pictures that we received, I really think it has to do a lot with what they have to look at and what they've looked at in the past and maybe what they're going to look at in the future, and they have some concerns around that. As far as the permits go, I mean, I guess we need to get some clarification on that, not to belabor the point, but maybe we need that, maybe we don't. I'm not sure that, but I'll let the other members have something to say. Thank you.
I guess I have one question. It would be addressed to the petitioner and I guess to the commissioner. Has the criminal violation that was issued on March 18th, has that been resolved one way or the other? Because according to the violation, it states that the interpretation was that changing a single family into a two-family. Has that been? I am? Yeah. I am? I'm on the wrong one? Wow.
But that's a good question, though.
I apologize. You know what I did? I wrote the numbers, we took them out of sequence, I apologize.
Jack's our oldest member.
Yeah, I did. I wrote the numbers down incorrectly, and I was going to... I guess then the only other question I would have, which was brought up by Mr. Bailey, would be specifically, what are you willing to do to accommodate the abutters? And I guess that's the principal way this can be resolved. If you're willing to make concessions, and that's something, I don't know what's transpired prior, what kind of conversations have you had with the abutters to address something that can be done amicably? You know, is that something that's transpired between you and them?
Like I said,
Perhaps that's what needs to be considered, and maybe before the board were to vote, maybe if parties are willing to get together and come up with some kind of compromise and then come back, perhaps then the board could vote with a little more conscience. And I guess that would be the question I would ask. As Bill said, I mean, this is really an issue of, from their perspective, of what they're seeing and what they believe infringes on their aesthetic view, the view of the neighborhood. You have a different perspective. Is there a compromise that can be reached? Is that something that, that you can consider? Did you approach them at all at any time prior to this? Because that's one of the main issues we deal with all the time, is when a petitioner makes, you know, the motion for a petition, what's incumbent upon you is to reach out to all of the abutters. And those that are unhappy find a way to compromise prior to coming to us.
Well,
and then it makes our job a lot easier.
right, like I said earlier, I apologize for being here. We should be home watching the Red Sox right now, as they're fans and we are fans. But this, we just requested this year. And as I was doing my projects, they would always have, you know, didn't approve of this and didn't approve of that. So for me to go over there and, you know, I knew they weren't gonna, they were gonna oppose it. So that was the reason that we didn't confront them on this issue. But like you said, I'm willing to compromise with whatever, like I said, whatever they want me to do. If they put up a 8-foot fence, 10-foot fence, if that's what needs to be done, I'll take down the other one. And
Through you, Mr. Chairman, that's what I would recommend is perhaps we can look at a continuance, and if the parties are willing to get together, then come back before us if they resolve it. If they're not, I mean, I don't know what else to suggest. I think Bill is absolutely right. They've taken photographs based on what they see. I mean, is there any way that the abutters who spoke, do you have...
could I take a look at the picture?
You're going to need to speak from up here.
Can I take a look at the pictures?
Oh, yeah, you're entitled to a copy. I thought you had a copy.
No.
Take my copy.
Yeah, we're not opposed whatsoever with them having the deck. We're opposed to them coming towards our property in violation of the setback. We don't understand why they don't just come out 5 foot and then wrap the deck around the side of their house and not be in violation of the setback. They have other opportunities to put up a deck, fulfill all the regular requirements here. Pure and simple. We don't understand why they need to put it coming straight back towards our property instead of going beside their addition or on the other side of their house. If they can answer to us why they can't do
that goes along with my question. So you're asking for a variance, so you know you're going to have to show, pursuant to the standard, you have to show us the reason where is your hardship here as it relates to the shape of your lot or the soil condition or something like that. I do see the shape of your lot being an issue because you have an elevated slider and you've got to get onto something. But that would be good if you had no other place to put it. But if they're right, and I don't know whether they are or they're not, but if you have another place in your house going off the same slider where it wouldn't affect anybody's view, why wouldn't you do that way? And
No, wait. As you can probably see in the package that we gave you, our property is sort of in an angle. And it's sort of in an angle, so the only space that we have to put a deck would be that specific place, with that specific space there. We did talk to the permit board, not the board,
The building inspector?
The building, yeah, and they said that because the way, where the pool is, we don't have enough space to put it closer towards the pool, so.
Sure.
So the only space that we really have to put the deck would be in that specific area.
You can't talk to me from here, though. You can, if you just explain to me from the, only because they're listening at home, so you need to make sure everybody can hear you. So I have the picture, sir.
If I could go in front towards the pool, I would do that. If I can get approved for that, I will do that, and that wouldn't be a problem with me. No, what I'm saying is I'll do, coming out the slider on the other side, and in the front, there's no room in there. That's the 495 fence is there.
What's there, sir?
They're suggesting that I do it in the front of the house, but that's where the 495, the fence divides the 495 and our front yard. There's absolutely no.
Okay, I guess, I'll just tell you maybe a continuance, and I agree with Jack's probably the best way to go, but I could tell you, what I'm thinking, so if there is a continuance, at least all you folks know what to talk about, at least from my perspective. I think, I think he does meet certain requirements, and I'm looking at the shape of his lot, and I can see a hardship. Would normally be a relatively minor request for relief. However, I see what you've handed in, and I'll credit it. I don't blame you at all for being upset. I mean, if two different colored houses, there's something going on. Some things may or may not have been pulled the permits. I don't know that, so I can't say that that's the case. I have to give them the benefit of the doubt that they had the permits, because I don't have anything that shows that they don't. If you want to go from the podium, you can. But let me finish what I'm saying. So, and I do see that you have a very nice deck as well. So I understand why you're upset, and you may be upset with them, but you folks are going to live together for, who knows how long in the same neighborhood. So I agree with what Jack said. If there's a way that you can come to some sort of agreement, considering it's a relatively minor request, and considering that you do have a deck of your own, what would make it work for you? Maybe you can get, some of these other issues resolved if we put some reasonable conditions on as to what you would suggest might help everything, and maybe it can be a win-win for everybody. It's just a suggestion, it's just what I'm thinking at this point. Doesn't, mean that's what my vote's gonna be, but at this point, that's how I'm thinking. I would be willing, if the board was willing, to suggest a continuance for 2 weeks or till the next meeting or the next meeting after that, to give everybody time to look at it. What I also need to know, sir, is what type of deck are you planning to construct there? Is there a picture of it?
Yeah, we gave,
I'm not talking about a drawing.
okay.
Because what I think this board, at least what I need to see, and my guess is what the board's gonna need to see, is they appear to have a very nice deck, and they probably don't wanna see something else that, in their opinion, was just thrown together. If it's gonna be, a nice deck and maybe not an eyesore to look at, it might, give you a little bit of leverage here. So, for me to vote on it, I would need to see the deck, and what I'm talking about there is an artist's rendition of what kind of wood are you gonna use, what kind of railings, what kind of, anything to dress it up to make it look better, or possibly some screening. I don't know, maybe you can get one of those decks with the, forget the kind of wood, but it's basically all closed in where they can't see through it. I don't know if that works for you, but I've just thrown out some possibilities. So rather than go through this, and I mean, you could take, if you want to vote tonight, sir, you're entitled to it. So you do not have to accept a continuance. It's a suggestion. If you say, you're prepared and you just want to go with the vote tonight, then we'll be happy to do that.
No, I'm willing to sit down with them and work it out. If I have to build a wall right there so they don't have to look, well, we got the grill there, because they got, like I said, and you know what, it's funny that they showed pictures here. I mean, the fence was down, there was a storm, and the fence blew, and I had to deal with the insurance first, and take pictures before I can just pick it up. They want it. That's why I was there for a few days, because the insurance was taking so long. Right. And I told them, listen, my neighbors are getting mad at me, we need to do something.
Well, Well,
Yeah.
I think if you sit down with them, I mean, you're next door neighbors, so it's, you know.
We're going to be there for a while, and I'm sure they are too. So, like I
So
said,
as a suggestion, we could continue this, I think,
Mr. Chairman,
go ahead.
can I ask
Sure.
a couple more questions? What year did you occupy your home?
I purchased it in 1993.
93. So you were there before okay. But that home was thrown up the way it is. The front door is facing towards 495, the way it existed, right? The other thing I wanted to ask was the sketch that's on the back for the proposed deck. Is there a reason why the steps are going the opposite way of the pool area?
where the steps going to?
They're actually heading away from the pool area.
Because we didn't want it going towards their property anymore.
No. I'm talking about the steps to get off of the deck. They're not even going in the direction of the pool area. Is that the way it's supposed to be designed?
Itself is not connected to the, it's not gonna be connected to the pool.
Yeah, that deck's not going to be
No,
connected.
I'm not saying it's going to be connected to the pool.
It should be, the stairs should be going down towards the pool. Is that what you're saying?
I'm just looking at what was submitted. I'm trying to understand why the steps going away from the pool area. I suppose you could have steps going down. You should have them going both ways, and I think the chairman, Mr. Chairman, are you asking for a better submittal for the next meeting?
I mean, absolutely, for my
Right,
purposes,
yeah.
I want, you know, whether you can go on the computer, or you could take a picture of a very similar deck, or the exact deck, and maybe it might not be the same size, but you could say, this is what it's gonna look like, and if it's approved, would have you sign that.
Okay.
And if it's not substantially the same as that,
Yeah.
then, you know, we would ask you to take it down, so.
You're going to have a
That would be-
contractor do it, or are you doing this yourself?
Yes, this guy does decks for a living.
I'm sorry?
The gentleman's doing the deck, he does decks for a living.
Yeah. Well, you might want to work with him to come up with a
Okay.
better plan that we can take a
Well, that was
look at.
just because she is
Okay.
also an artist, she's
Sure.
just a rough sketch.
Oh, no, I'm not, I'm just suggesting, I think that's what the chairman's suggesting too.
Right, we just don't want to have to continue this again. We're trying to give you, I mean, all the board members will point out the issues that they may have. You folks can go back and at some point sit down and see if you can come to some resolution, and if you can't, you come before the board, and the board will take a vote, and, you know, you live with what the vote is. Just trying to, I think it's just, where you live right next to each other, and you've been there for a long time, and you're going to be there for a long time, if you can compromise and maybe, you know, it could be something that's acceptable, and there's not going to be any animosity between the parties if somebody's not happy with how this board votes. I do think, from my perspective, though, you know, the shape of that lot and how it is elevated there, and they have the deck there, you know, I think he does meet certain variance requirements, but I do understand your point, every single one of them, and I'd be upset if I were you as well. So that's just how I'm feeling right now. I don't know how I'd vote, but I'd much rather have you come to some compromise that the board can put reasonable conditions on it and
Okay.
go from there. And if you can't, you know, we'll take the necessary action.
Okay, understood, and have a good night. Thank you.
Thank you. Okay, so we have to vote, first of all, to do that, so don't go anywhere yet. So if this is, I guess I need a motion, and the motion would be possibly to continue it to the next hearing, which is the 27th of October. And just so you know, that is not a very heavy agenda, so we could probably get to
Excuse me,
it
Chairman,
pretty
I
quickly.
w- I won't be here the 27th, so. we'll do
Okay.
the-
When is the next, Stephanie, after the 27th? November 10th. Does that work for you, ladies? Okay, so I guess that's what, the date, that gives you plenty of time to get, because you probably would need a little more than 2 weeks to get everything together.
Right.
Okay, I'll entertain a motion to continue.
Motion to continue till November 10th.
Second.
Roll call, please.
Continue?
Continue.
Continue to November 10th.
Continue.
Continue.
And Stephanie, just to correct the record, Mr. Noon is not voting because he wasn't here at the original petition, so we'll just, let's take a revote.
Continue.
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 Okay, this matter's been continued to November 10th. There will not be any further public notice, so you just have to be here that day if you want to. Nobody's required to be here, but you are, if the petitioner certainly is. If you work it out, great, and if you don't, we'll be willing to hear your petition and vote on it that night. Thank you, everybody. Thank you for your time.
Thank you.
Okay, the next petition is ZB 2008-37. This is a special permit and variance request from Paul Bowden, care of Attorney Kenneth Cossingham, the Kenneth Cossingham Law Offices, PC. The address is 71 Lupine Road. This is in its traditional single-family zone, and the petition is to maintain the legal use of a pre-existing two-family according to Section 12(1)B within sufficient lawn area, frontage, and side yard setback according to Section 5.1, and without the required parking according to Section 6.1.4 of the zoning ordinance. Attorney Cossingham? Welcome, sir.
Thank you. Thank you, Mr. Chairman. We are addressing that, that notice of criminal violation that Mr. Knox referenced before. And let me just give you some history. Mr. Bowden, my name is Attorney Ken Cossingham, offices in Andover. I represent Paul Bowden. Mr. Bowden is with us tonight. Mr. Bowden is the owner of 71 Lupine Road. The property has been in the Bowden family since 1951. You have the deed where it was conveyed into his mother. Mr. Bowden actually lived there as a child, was raised there, has been there, and has been in the Bowden family ever since. When she passed, he inherited the property, so it's been in the Bowden family since 1951. It's our position, and I'll give you the evidence, it's our position that it's been utilized as a two-family residence at least since 1951. And it's been assessed as a two-family residence at least since 1971, and I'll give you the documentation that supports that. In 1971, it was a valid use under the 1971 zoning, so it's a pre-existing non-conforming use. The problem we ran into in the notice of criminal violation in March was this. The original building permit for the property in 1929 was issued as a single family. So the notice of criminal violation that was issued in March was not on a zoning basis. It was for a violation of the original building permit back 71, I think it was, years ago, the 1929 building permit, because the 1929 building permit was a single family. When I spoke to Mr. Camacho's office and we went through this, the remedy to bring this into compliance is to apply for a new building permit as a two-family. But I can't do that until I have proven to this board that it is a pre-existing non-conforming use, that it's been a two-family for sufficient time under the ordinance before I can go back to inspection services and apply for the corrected building permit. So my job here tonight is to show you it's been a pre-existing non-conforming use and that it's a legal use. Our evidence is twofold. Number one, testimonial evidence. Mr. Bowden is here tonight. Mr. Bowden's testimony is that he's lived there. He lived there as a child. His family's been there since 1951, various members of the family. And throughout that entire time, since 1951, it's been utilized as a two-family. So we have testimonial evidence that brings it back to 1951. In terms of the documentary evidence, I'm going to pass out some documents if I can.
Sure.
Now, these documents are contained in the package I filed, but the package I just gave out is a little more tabbed and highlighted, so it's a little easier to follow. If I can ask you to look at tab B on the package I just gave out. Tab B on the package I just gave out is a copy of the 1971 assessor's records for this lot. In 1971, the assessor's records showed this to be a 2-apartment house. So 1971, the assessors recognized it. It's our testimony. It's been utilized at least since 1951, but it was recognized in the assessor's records as 1971 as a 2-apartment house. Then if you look at tab C in the documents I just passed out, you'll see the current assessment. The current assessment still is as a 2-family house. So from 1971 through the present, through today, it's been assessed as a 2-family. Now, to show that it's a validly existing use, we go to tab D. The first page on tab D is the 1971 zoning map, and I've highlighted lupine there on that map. You'll see that in 1971, it was in an M1 district. So in 1971, it's assessed as a 2-family. It's been used as a 2-family for at least 20 years, and it's in the M1 district. If you go 2 more pages, you'll see a copy, and it's a poor copy. I apologize for that. It was colored paper, and it did not copy well. But you'll see a copy of the 1971 zoning ordinance. This we obtained, through the city, of course. And in the M1 district, it's utilized, a 2-family house is a permitted use in that district. So what we have here is a valid use as of 1971, and the testimony is it's been a continuous use since that time, and at least since 1951, and assessed since 1971 as a 2-family. I suggest to you that we've carried our burden of proof that this is a valid use, a valid pre-existing use. It is, as the chairman mentioned, it is in a traditional single-family district today, and which does not allow 2-family. But as of 1971, it was a valid use, and it's been continuous. Now, in the application that you have a copy of in the bound set, under tab A of the application, we identify the various deficiencies. Note, these deficiencies are under the current ordinance. There are no deficiencies under the 71 ordinance. We're a permitted use under that. These are the deficiencies under the current ordinance, and there's 5 of them. Number 1, use as a 2-family, okay? Number 2, there's insufficient area, frontage, and side setback under the current ordinance. However, all of those were complying in 1971 and continuous use, so I suggest that they're covered by the pre-existing use, the pre-existing non-conforming use. Number 5, parking. I must make a correction, and I apologize for this. When my client is from New Jersey, and when he looked at this evening as part of arriving for this, he pointed out a mistake I made. I indicated in this chart that there was only 2 parking spaces. There are, in fact, 5 parking spaces, so that would bring it into compliance, even under the current statute. That includes the garage out back, the driveway, as you'll see on your plan, the driveway that runs, there's a parking area in front, there's a driveway that runs from the parking area beside the building to the garage out back. That's all paved, and there's actually 5 parking spaces there. So what we have here is the two important points to make, and these are points that I want to be sure the neighbors understand as well. We're not changing the use one bit. There isn't any change in the use that we're proposing. This is the same use that's been there at least since 1951, and we're not changing it one iota, okay? There is no change. It has been used as a 2-family by the Bowden family. They've rented out that second unit to various people over the years, including one of the neighbors who's here tonight, who I understand rented one of those units in the 70s. Okay, I may be wrong on that. Okay. But this is the use that has been there since 1951, and we're not changing the use, sorry, we're not changing the use one bit. We're not changing a thing. The only thing we're doing is asking this board to recognize its status as a pre-existing non-conforming use, which I suggest the evidence shows it is. That will allow us to go back to the inspectional services, to the building department, get a corrected building permit so we come completely into compliance. But we're not proposing a change at all. We're simply correcting the paperwork, okay? The second important point to make is this. Mr. Regan, who signed that criminal notice, the March criminal notice, at the suggestion of Mr. Camacho, visited the property along with the broker to confirm that the property structurally is a two-family, that it's internally configured properly as a two-family. And he did confirm that it is structured internally as a two-family, so we don't have any internal violations as a two-family. Their only violation is back 71 years ago when the building permit was issued, somebody put down one family instead of two. That's the only violation that we're trying to correct here tonight. But we're not suggesting one change at all. We also have with us tonight one of the potential purchasers is also from the neighborhood. So when this is corrected, this has been inherited by Mr. Bowden after the passing of his parents. We're trying to put it on the market. There is a potential purchaser. He is a neighborhood person, so the ownership will stay in the neighborhood as it's been all these years. So that would be our presentation. We have a pre-existing non-conforming use supported by the documents, supported by the evidence, and we're not changing it a bit. We're simply cleaning up some paperwork. That would be our presentation.
I guess my question is, if you have if you got the criminal notice,
yes,
and you can correct me if I'm wrong, because I'm sure you know better than I do, but if there is an appeal period to that of 30 days, from what I understand, according to 40A Section 15.
Right.
And if you don't appeal that procedurally and timely, then you waive that appeal, so the historic use, at least in my thought process, would be irrelevant to the argument, and then you'd be before us looking for the petitions and special permits as requested.
Well, the procedure we're following is this. Instead of trying to, in an appeal, show that decision was wrong, we're trying to correct the decision. In other words, understand that criminal violation. The only criminal violation, or the only violation it cites, is the 1929 building plan. It doesn't relate to zoning. It's not suggesting we're in violation of zoning, because we're not. The only violation is that the 1929 building permit said single family instead of two family. So instead of trying to prove it's wrong and have it overturned on an appeal, we chose the route of correcting that permit. Now I have to have your board confirm that zoning-wise it's a pre-existing non-conforming use. Then I can come back to inspectional services and have a new permit issued. So that would take care of the violation. There's no doubt, frankly, that the 1929 building permit says single family. So to appeal it and say that observation in the criminal violation was incorrect would not be accurate. The 1929 permit does say single family. But as long as it's a pre-existing non-conforming use, then that gives me standing to go back to the building department, get a new permit, and come into compliance that way.
But wouldn't the question be, is it a legal or an illegal pre-existing non-conforming use?
Well, it's the term pre-existing
presumes legal, I understand.
Yeah, presumes legal, and it all that relates to the use. That relates to zoning. Doesn't relate to the building permit. Those two different sets of rules and regulations. You'll
Right.
see in what I handed you, my original response to the building department was, well, I'm fine under zoning, and they pointed out to me, and accurately, that they're not saying I violate zoning. They say we violate the building permit. That's a completely separate and distinct set of regulations. And as long as we comply with zoning, we can correct the violation under the building permit. Does that make sense?
No, I understand the position you're in. I guess I still have, a basic problem of, it's a single-family house, so it was never a two-family, and I know what you're saying, it's been used as a two-family.
Right.
But that doesn't mean it had a legal use as a legal use.
But it did because of the 1971 documents. I've shown you in 1971, it was a permitted use. So the use in 1971, at least in 1971, I couldn't go earlier than that in the records, but at least since 1970, as of 1971, it was a legal use. It was a permitted use.
But wouldn't they have to have gone in 1971 to say now we want it as a two-family when it was a single-family? Because I just don't have any documents that show that it became at any point a legal two-family.
Well, I suggest to you the term legal is a zoning term.
Mm-hmm.
And it became a legal under the zoning rules in 1971, at least in 1971. We think it was much
Just
earlier,
by
but I can
itself?
document it in 71.
I mean, would it just become,
It's still in violation in 71 of the separate code
Right.
of the building permit. It's still in violation of that. But as long as this board recognizes its zoning status, I can correct the building permit.
Well, I think that's where there might be a problem, but, it's a, okay, I understand your position.
Okay.
But I guess I'm confused as to what you're petitioning. According to the application, you're looking for the variance and the permit, so, the board would have to use the standard that they use, for the variance and special permits. But on the other hand, what you're saying is that you're looking for us to, ratify a pre-existing non-conforming use.
That it truly is what we seek. And again, I think you point out accurately, it's not truly a variance. We're simply looking for ratification from this board that it is a pre-existing non-conforming use, and then I can correct the rest. Well, I can apply to the department to.
Okay, I understand, it's a little bit confusing, but I understand
It
what
is.
you're saying. I understand what your application means now, but, okay. All right, is there anything else you'd like to say, counsel?
No, that's our presentation.
Did your client want to offer testimony?
Do you want to just say it's used as a two-family throughout?
Sure, yeah.
Please state your name and
My name
address.
is Paul Bodwin. I'm the owner.
And where do you live, Paul?
Right now, I'm living in New Jersey, but I own the property at 71 Lupine Road.
Okay.
And I've lived there for 46 years. I was born there. And the property, as long as I can remember, has always been a two-family. Most of the time, we had relatives who were living in the apartment. We did have one neighbor, Mr. Poria, who did rent there prior to purchasing his property in the neighborhood. It's a very nice neighborhood, and there's nothing that I want to do to change the complexion of that neighborhood. I want it to just to remain a nice neighborhood, and we're planning to sell it to someone who resides in the area, in the neighborhood. So we'd just like to get the paperwork straightened out so that we can go ahead with the sale.
Okay, thank you, sir.
Yeah.
Okay, is anybody here, anything else, counsel?
No.
At this point, you could speak again if you, anybody here wishing to speak in favor of this petition? In favor? Okay, hearing none, that portion of the public hearing is closed. Is there anybody here wishing to speak in opposition? In opposition to the public hearing? Oh, please step up, ma'am. State your name and address for the record before you speak.
Hi, my name is Patty Crabtree. I live at 70 Lupine Road.
Mhm.
I live across the street from this, what appears illegal two-family, not necessarily existing. Since my husband and I bought the home, it's only been occupied by the Bodwins. So if it was to be a two-family, how they split up the interior of the home, I don't know, but there's only been Bodwins, and we've lived in our neighborhood over 7 years.
For the last 70 or
For
7?
7,
I know
actually
you-
8.
I know you didn't live there
8,
7.
70, no, 70 is the address. All 4 butters are here tonight, as well as neighbors on both sides of abutters, as well as a letter from a neighbor on the opposite side. The issue is that if it was a pre-existing, but we need to call it illegal two-family, it was built as a single family. The Bodwins, their parents, from what I gather, I wasn't there at the time, but a lot of history in the neighborhood, the parents got sick, and they kind of in-lawed and made the apartment ready. And of course, it's a neighborhood, and I don't think anyone might have minded that situation. But every house around it is a single-family home. We're a traditional single-family neighborhood. And I don't think it supports the parking for a two-family. It doesn't have the frontage for a two-family. And if we were to go back to ordinance and say, okay, well, when my husband and I moved in, it was a traditional two-family. Could I have made my home a two-family and then turned around now that we're single-family and said I'm pre-existing? I don't think it really works that way. I mean, each and every one of us are here to talk tonight in opposition, all four abutters, and like I said, neighbors on either side of that as well as that.
Okay, thank you, ma'am.
I've got a letter from one of them that couldn't be here. She's sick.
Okay, if you want to show a letter, as long as you just show it to council for the petitioner first. And then he can bring it up to me at his convenience.
I want to say one. Mr. Comtois lives around the corner, and you
Mr.
know,
who?
Mr. Comtois, who wants to buy the house, and he is in the neighborhood, and that would be nice. But the only thing is, if he was to leave, we are allowing a two-family in a single-family neighborhood. You know, had he bought it, and then if he wanted to have his brother move in, so be it. But there's not enough cars to support. There's not enough parking to support. There isn't 5 spaces, as they say. And I'll let Chris is here and Mr. Poirier is here, and whether he rented or not at the time, I mean, did they qualify that as income? I don't know, because, like I said, I've only known the Bowdens to live there. I have not known it to be a rental unit.
All right, well, we'll listen to everybody who wants to speak.
I know Mr. Patnard wants to go home, so.
Anybody else wishing? Sir, you can address the board. Please state your name and address for the record.
Yes, I want to introduce myself. My name is Lionel L. Patnard, and I'm a registered professional engineer. I've been, all my life, I've lived on 62 Lupine Road, which is exactly almost across the street from this property that you're talking about.
How long have you lived there, sir?
I've lived there for 68 years. I raised my family there. I've seen the course of action in that property. I know who lived there when the property was bought. And Mr. Bodwin bought the property, and it was a single-family house. And how in the world could anyone live in if it was a two-family house when he had 5 children? They needed the space. There's no way it could have been a two-family house. And furthermore, Lupine Road was a farm road. When I first moved there, it was wonderful. We had no sidewalks whatsoever. It was very peaceful. We had no problems whatsoever. But now, let me tell you something. It's like Times Square. Right across the street from me was a single home. They put up 4 condos. We have, right in that particular district, we have 8 new automobiles. 8 new automobiles. And one of the reasons that I'm here today is because just about a week ago, we come out of our parking lot, and what happened? Bingo! We got hit by one of these cars. We have children living in the neighborhood. That there's no sidewalks. And it's very unsafe for people to work, to children to walk across the street. It's very dangerous. I don't want to have any child killed on my street if I can help it. And that's why the reason I'm here to talk against it. Let's have a good neighborhood, and then furthermore, we do not need any more park. We don't need any more cars. You put a two-family house there. There is no 5 parking spaces. If they can show me 5 parking spaces, I don't know where they are. It's impossible to have 5 parking spaces there. And we have 8 automobiles in front of us. Now we're going to be contended with 12 more. My friends, if you want to keep Lowell as a decent city to live in and to have your children brought up safely, let me tell you, you should go ahead and throw away this request and do the right thing. I thank every one of you. It was a pleasure to be here.
Thank you, sir. Anybody else wish to speak in opposition? Please step up to the microphone, sir, and state your name and address for the record.
Hi, my
Hi.
name is Christopher LaValle. I live at 63 Lupine Road. I'm actually in one of the 2 condo units right next to the property. The other condo unit is also occupied by a family with a newborn daughter. My wife actually just gave birth, so we're raising a family of our own. And we like to keep the neighborhood as a family neighborhood. And I don't know about pre-existing conditions. I've only lived there for about 3 years, but it is a nice, quiet neighborhood. It's a wonderful neighborhood that I've wanted to bring up my daughter in. When I heard about this petition, I did some research online, looked at some of the zoning ordinances, and also looked at the maps online. And I took some pictures of the property to show you that there really is no 5 parking spaces there.
Do you have those pictures on you, sir?
Yes, I do. I apologize, I only have one set.
That's okay, we could pass them around.
I also have a picture of my wife's car parked on the street where off-street or on-street parking would be. And in the past, there have been cars there that have often, because there's no curb, been parking on my grass. So that has been a challenge to keep up that grass. But looking through the ordinances, it did seem, and of course you can correct me if I'm wrong, but it seemed like there, in order to have off-street parking, it needed to be a minimum of, or a maximum of 3 feet from the building. And as you can see from these pictures, the pavement goes right up to the building. So what they're considering a parking space really would not be wide enough with those 3 feet for width of a car. So I can give you these pictures. Also, the zoning map that I did download from the GIS website, the Lowell website, does show the fence line that's there, as well as our property line. And what you can see is the property line is actually further towards their building than what our fence is. So you can see in the pictures where the fence is, and I'll also give you the downloaded map to show where the fence is in relation to the property line.
Hey, sir, if you could just show those pictures before you bring them to me to Attorney Cossingham? And then if there's anything else you'd like to say?
Yes, I don't know about the pre-existing conditions of that house, but I do think the key is that it seems to be an illegal pre-existing condition. And I would not want to change that neighborhood any more than it already is. We've got wonderful tenants in all of the condos. There are 2 duplex condos in that neighborhood, and it's like living in a single-family home right next to another single-family home. So it's got a nice family feel to it, and we just like to keep it that way. Thank you.
Okay, thanks. Ken, if you've looked at those, you can bring them up so I can... Thank you. Anybody else wishing to speak in opposition? In opposition? Step up, ma'am. Please state your name and address for the record.
Oh, good evening. My
Please,
name is
please pull the mic down so you can speak into it.
My name is Sajda Sayyed.
And where do you live?
I live on 75 Lupine Road, and it's just next to this house, 71, and our windows and their windows are very close. If it's open, it's like we are sitting in each other's house. And Joe and Piaget is my good friends. His sister was my good friend, so I feel bad to be here, because if they will live there, I will be more than happy. And the honor, I know nobody was, it's not like some stranger lived there and came and left. They were all their family, they were living there. And it was nice, beautiful, and it's a one family neighborhood, and we don't have a commercial, like a business apartment kind of family there. We live there, and I am living there for last 13 years. And
For how long, ma'am? 13?
Since 1996. 13, almost like 13 years. So my concern is that we have little children, just as my neighbor has 3 little children, and we have very small area, and this 2-family house, if they will, first of all, it's not 2-family house. I never saw any 2-family living there with children. They were all their relative, and they were not like on the other side married with wife or children. No such thing were there. So my worry is for the future, if whoever will come there and live there as a 2-family, which this place is not as for 2-family, it's going to be not convenience for all of us in the sense of traffic, and God's know who is there, and they will come and leave and come and leave, and we are still living there for many years.
Okay, thank you, ma'am. Anybody else wish to speak in opposition?
My name is Richard Poria. I'm an abutter. I've been in the neighborhood for 38 years.
What's your address, Mr. Poria? What's your address? Where do you live?
I live on the Roger Street, 13 to Roger Street. Their backyard abuts my side yard.
Okay.
I can't imagine there are 5 parking spots there. I mean, I don't see it. And their garage is actually right on the property line of my line and their line. I mean, they don't have the necessary anything. They don't conform as far as I'm concerned, and I don't believe it should be a 2-family.
Have you lived there for a long time, sir?
38 years in that neighborhood.
Do you remember anybody else living there other than the Bowdens?
I cannot hear you.
Do you remember anybody else living there other than the Bowden family?
I still can't hear you.
Okay. Do you, if you want to step a little closer, that's okay.
Yeah.
Do you remember anybody else living there other than the Bowdens family?
I do.
Oh, yeah.
I do.
Yeah.
I lived there from 71 to 73 probably.
Okay.
And I had to park one of my vehicles out in the street. There wasn't
Okay.
sufficient parking, and there still isn't sufficient parking.
All right. I guess my question is, do you remember that in that house that we're talking about, the 2-family,
Yeah.
do you remember anybody else living there other than the Bowden family?
Generally, the Baldwin family.
Okay.
I mean, I did live there 71 or 72.
So you just lived there for those 2 years?
Yeah.
Okay.
1 or 2 years.
Great. All right. Thank you, Mr. Poria. Okay, anybody else wish to speak in opposition? In opposition? Okay, you get 2. You're next, sir.
My name is Anne Marie Page. I reside at Fremont Street in Lowell, and I'm the president of the Centerville Neighborhood Group. I'm very happy to see these neighbors here speaking up for their neighborhood. The last thing Centerville needs is another duplex. And this isn't the first time we've been here because of this particular issue, only in other streets. Oh, it was a 3. Well, now it's a 2. Well, it was a 2. We're going to make it a 3. Well, it's been a 3 for 40 years. Well, it was an illegal 3. There's something about the word illegal people have trouble with in Webster's dictionary. So the thing of it is this. If it's a single family, it's a single family. If it's a congested neighborhood, the last thing we need in Centerville is another duplex in a congested neighborhood. Really. I do appreciate the fact that you give all this time so that the neighbors that live on the street and are going to live with whatever problem arises, you give them the time to explain to them what they're going to live with your decision. We depend on you to make the decision for our quality of life, and we do appreciate what you do. Thank you very, very much, gentlemen.
Thank you. Any, sir? I didn't see those.
Thank you. My name is Stephen Rochette. I live at 55B Lupine Road. I'm one of the condexes that are a butter to this property. And I just want to say that I'm also in agreement with my fellow neighbors that it needs to be staying as a single-family property. Thank you.
Thank you, sir. I'm just looking at these pictures. I hadn't had a chance to look at them. Okay, anybody else wishing to speak in opposition? Okay, hearing none, that portion of the public hearing is closed, and the public hearing is closed, so we'll open. Sir, hold on. Please step up to the podium.
My name is Joe Contois. I live on 18th Rosa Street.
Yep.
If this house is recognized by you guys as a two-family, does the laws in the neighborhood still a single-family residence? I mean, nobody can come in and build duplexes.
Oh, yeah, yeah. I'm not sure. I want to make sure I understand what you asked me. You're saying if it stays as a single family, are you asking?
No, I'm saying if this house is recognized as a two-family, that doesn't give anyone permission to come into the neighborhood and build duplexes. Right.
It's in a single-family district.
Because the law was changed from a multifamily neighborhood to a single-family neighborhood. So I'm saying if this house is grandfathered in as a two-family, it doesn't give anyone permission in the neighborhood to make their houses two families.
Okay.
Okay.
Thank you for your input. Thank you, sir. Anybody else wishing to address the board before I close the public hearing? Sure.
The main issue here is that we're not making a change. This has been a two-family since 1951. And to that point, I'm going to ask Mr. Bowden to testify again, if I may, in a little more detail about the history of the occupation of that house. We are not proposing a change. We're not creating a two-family. It's been a two-family for 70 years. So with your permission, I'm going to ask Mr. Bowden to testify in a little more detail about the occupancy history of that house from your personal knowledge. It's better from personal knowledge than Can you just tell us who's lived there, what the history of the occupation of those two units has been during your lifetime?
Well, we've had a lot of people who have moved in, and most of the time they were either people who were elderly or people who were just starting out. And Mr. Poria here was one of the tenants there, and it provided him with the means to proceed to home ownership in that very neighborhood. And we have, over the years, had a steady stream of people who were mostly, my father worked for St. Louis Church, so they were mostly parishioners, people that were friends of the family, and also family members. Now, most recently, the last people to live there was my daughter and my granddaughter, who lived in the front unit, and my son lived in the rear unit. Now, throughout the years, for the past, as long as I've been alive, we have had, this has always been used as a two-family. We had Mrs. Gagne who lived there. We've had my older sister who lived there. And after her, we had the Porias who lived there. And following the Porias, we had this other gentleman who had just gotten married, and he stayed there until they had their first child, and then they moved out to a larger family, a larger house. And after he moved out, I moved in there for a while, and my parents were living in the front. And then my mother remarried, and she moved out of the front, and I moved from the rear unit to the front unit. And then after my parents aged a bit, they sold their property, and they moved back to Lupine, and they lived in the back of the house. Now, the question about the parking and what Mr. Patnod, the first person, said regarding the traffic in the neighborhood, it pertains to the townhouses that were built directly across from his property and abuts my property. So there's a bank of 4 townhouses, and they have cars going in and out of that bank. Prior to that, we only had a single-family house there and my property next door to it. So with the change in the townhouses, it's increased traffic somewhat. Now, the houses on that street are not just single-family or the townhouses. They have a multiple number of tri-levels at the end of the street. And they also have a duplex at the other end of the street. But it's sort of a mixed neighborhood of single-family, multifamily, townhouses. So you kind of have quite a mix of dwellings in the neighborhood. But the property has always been a 2-family as far as I've been alive.
Do you get utilities?
Always.
2 separate utility bills?
There are 2 separate utility bills. There's 2 separate meters, and the meters, the bills are sent to the 2 separate units.
Do you have 2 separate mailboxes?
There are 2 separate mailboxes. There are 2 separate entrances. And they are not connected.
Okay. What we'll do is everybody's had a chance to speak. I'm gonna keep the public hearing open for the purposes of any board members who have questions of the petitioners. Because once I close the public hearing, that's the public input. Excuse me, listen, we're not, ma'am, I understand, we've heard everybody, we're trying to, ma'am, please, please, it's not helping your case at all.
There are 2 entrance and exits for both units. There's an entrance for the front and the rear of the house. There's a front door and a back door for the front unit. There's a front door and a back door for the rear unit. So there are 2 separate, it's a 2-family property. It has been a 2-family property. It's always been a 2-family property, to my knowledge. And I've been there, incidentally. I lived at that location for 46 years, long before most of these people were even in the neighborhood.
Thank you, sir. And Attorney Cosingham, because I allowed him to readdress the board, I am going to allow her 2 minutes to readdress the board, just because...
Can I just finish my rebuttal?
Yes, you can.
Okay.
Give you 2 minutes after that, ma'am.
Okay, and I'll do this quickly. I know we're getting late. Again, I provided you evidence that the town has recognized this as a 2-family continuously, has assessed it and recognized it as a 2-family continuously since 1971. It still does today. If you go downstairs and look at the assessor's plan today, or the assessor's records, and I've given you a copy as tab C, it is listed as a 2-family, has been since 1971. Mrs. Bowden is here and can also testify if you'd like additional evidence from personal knowledge, because she knows for the last few decades that it's been a 2-family. There's no doubt that there were times when there was only Bowdens, but they occupied the 2 units as 2 families, as 2 households, even though their last name was the same. The parents lived here, Mr. Bowden, the son lived here. The mother lived here at one point, the daughter lived in one, the son lived in the other. There were times when there were only Bowdens. But the point is, it's always been, and the evidence is clear, it's always been utilized as a two-family, been recognized that way officially by the town since 1971. In terms of the parking, real quick, I know we need to move on here. You have the plan that we did, it's in your package. And it actually shows well in the photographs that were presented as well. The area up front is a paved parking area. Plenty of room there for 2 to 3 cars. There's a paved parking area that runs, a paved driveway, I should say, that runs from the parking area to the garage. And then there's a garage in the back. Now, the parking regulations we're talking about, of course, stem from the current ordinance. And we're not required to comply with the current ordinance. But the current ordinance requires two parking spaces per unit. We even comply with that. Using the garage, we even comply with that, even though we don't have to. We don't have to comply with the current statute, this current ordinance, because we're a pre-existing non-conforming use. My final point is, it is consistent with the neighborhood. You've heard evidence of the 4 townhouses. You've heard evidence of other multifamilies in the neighborhood. Certainly there are plenty of single-family in that district, but there are also plenty of multifamily. This has been a multifamily, and legally, it is a multifamily. Would you like to hear from Mrs. Bowden and her personal knowledge?
Only if she's going to say something, anything different than your client already. Ma'am, please
My
state.
name is Teresa Bodwin, and I've lived there since 1973. And when our children got older, my in-laws lived in the back, we lived in the front. I had 3 children, and when they became teenagers, my in-laws had a car, we had 2 cars, and our children had 2 cars, and they all fit in the driveway. And as far as adding anything to the apartment in the back, when my mother-in-law had Alzheimer's, we had to stop her from going upstairs. So we had a bathroom built downstairs with just a commode, a very small sink, and a shower, because she could no longer go up the stairs. And we had to close off the upstairs to her. And that's the only thing that was added to that apartment. And they are 2 separate apartments, and with separate ins and outs to front and back.
Aside from that bathroom, was there another bathroom there?
Yes, upstairs.
No, in the apartment, in the second unit?
In the back half?
Before you put the commode in, was there already an existing bathroom?
There used to be, a long time ago, it was a doctor's office, but the bathroom was upstairs.
So there's separate facilities for each unit?
Correct.
Okay, that was my question. Thank you. Okay.
And again...
And separate kitchens.
You have to do it from the board, Ken.
And again, Special Services has confirmed that. They did an inspection and confirmed that structurally it is a 2-family.
Okay. Okay, ma'am, I agreed to 2 minutes.
Mr. Chairman,
Yeah,
may I ask a question?
Sure, you can ask.
Thank you. Please excuse me. No, I'd like to ask of, I guess, the attorney, counsel, and the petitioner. I own a 2-family, and the address of the 2-family is 5 and 7 separate addresses. What I see here is 71. Where does the other mail go? 73, 69? Where does it go?
It's front and rear. It's always been front and rear.
The question was, what is the number?
71.
That's one address.
Yes.
I own a 2-family. The address on the mailboxes, it's up and down. I have 5 and 7. My question is, it's an odd number. So is the second mailing going to 69, or is it going to 73?
No, it's going to 71, and it's always been front and rear. That's all I can tell you.
So there is no second mailing address. Is that correct?
There are separate mailboxes.
That's not what I asked. I asked if the post office is going to deliver a piece of mail, where does it go? Does it go to 71 for both parties? Is that what you're telling me? Or does it go to 69 or 73? Those are my
71.
questions. Thank you very much.
But they are legally, I mean, there are separate mail receptacles, separate addresses, separate utilities. And if I live in 71 rear, I don't get the mail for 71 front, because that's a separate mailing address.
Let me clarify that. I get a utility bill from the electric company, and on the utility bill, it says 71 Lupine Road, front, for the front meter. For the rear meter, it says 71 Lupine Road, rear. They are separate accounts.
Okay, and ma'am, 2 minutes, please. Please state your name and address again.
My name is Patricia Crabtree. I live across the street at 70 Lupine Road. Again, it's skirting around an issue here. The issue is it was built as a single-family home. As you just asked her, was there a bathroom in the rear? There was not. They used the one upstairs, which would be the front.
Please, everybody, listen, I have to...
I've never
Excuse
been
me,
in the
let me
house.
speak. I have to keep control of this meeting, so if anybody wants to address the board, you have to speak at the podium. You can't
Okay.
speak from your seats.
Well,
We're
I'm
not going to
speaking and I
recognize
didn't
it.
interrupt them.
Okay,
I'm just saying, as Sheena said, who's a direct abutter, we've never known it to be a two-family. I've lived there 8 years. Sheena's lived there 13 years. So if I have my cousin come in and put a separate electric or put another mailbox up, and then 15 years down the road, the ordinance changes, can I call my house a two-family? I've lived there. I'm telling you, it's not a two-family. Sheena lives there. She's telling you it's not a two-family. The Bowdens have lived there at 70 Lupine Road. I should have went over and looked at the meters. I have 3 kids. This neighborhood, and Mr. Patnod was not speaking of just the condos. The condos have a larger parking area. Yes, we oppose them, but at the time we didn't have the backing. Now we've got a chance, and you've got a chance to hear our voices, all of our voices. Mr. Patnod was saying, we can't afford 4 cars there. There's never been 4 cars there since I've lived in the neighborhood for 8 years, nor has there been in Sheena's 13 years. They didn't live there when I was there, so to say they've lived there, they live in New Jersey. They're looking to sell the house, conform it the way it was when it was originally built, as a single family. It wasn't a glitch, it was built as a single family. Well, I believe it to be.
thank you. Okay, does anybody on the board have any other questions before we close the public hearing?
I do, Mr. Chairman, I do have a question for the petitioner's wife. I overheard, ma'am, could you come to the podium? I overheard you indicated that when the chairman asked you about the bathroom that you built for your mother-in-law on the back.
Right.
You indicated that there was the downstairs floor used to be a doctor office. Could you expand on that?
When the house was first built, it was a doctor that built the house, and it was a office in the back, and he lived in the front. And there was an entrance that went in the kitchen into the back portion of the house, and that was closed off when my husband's family bought it, and it was put into another apartment.
So that house used to be also not only the permit as single, but also used as a doctor office?
Correct.
Was it a legal doctor office?
Built it originally.
Was it a legal doctor office?
I don't know the answer to that.
Thank you.
You may.
The Bowdens bought it in 1951, okay? It's been used as a two-family since 1951. Legally, the question is, was it ever legally used? And I've shown you that in 71, at least in 71, it was a valid use to use it as a two-family. It has been used as a two-family since 51. Now, there's no doubt that when it was built in 1929, it was built with the office, but that's not the issue. The issue is, was it ever legally used zoning-wise as a two-family? And we've proven that it was a legal use as a two-family The two-family use began in 51 at least, probably before that, but that's as far as we can document. And we've proven in 71 that was a legal use. That makes it a pre-existing non-conforming use.
Okay. You all set?
Mr. Chairman, I'd like to ask a question of you, if I may. And in the beginning of this, counsel for the petition mentioned something about our purpose here, in that we're actually voting on interpreting something which I'm not even sure we have the authority to do so. And should this go to the solicitor first to even interpret whether or not we have the authorization to determine whether this is indeed a single family or two family? And that would be my question to you, Mr. Chairman.
I think we do have, I think it's within our scope of the authority, although I do agree with you. I think we have a genuine legal question that may be needed to be answered by our city solicitor's office. You know, it's clear to me now that in 1929, the house was built as a single family. I don't think it was a mistake, the building plan. I don't think it was anything like that. I think, from what I heard from your client, I think a doctor built it. In those days, you know, there was no zoning. He put his office down the back. It was continued. It was an open area where he went through one hallway into his office. Two-family with his den, you could call it. You know, I'm just speculating, but
right.
My guess is that's what it was built for. I understand your argument. You're saying, but, you know, since at least 1971, it's been used as a two-family, and in my mind,
used since 51. We can
1951.
prove legality in 71. Yes.
Right, but I'm not sure that it was validly used as that. Just because it's been used as that doesn't necessarily mean that it was a legal use. And there could be a genuine, just a dispute over the interpretation. And, you know, I don't think, I'm confused at the application because just a little bit, but I can understand the position you're in definitely, because how else would you address the board? But
right.
I don't think that this board has enough information right now, or I guess, combined legal background to answer this question at a public hearing. And part of what we can do is request a formal opinion by the city solicitor's office. They will take the application, they will look at what you're asking, they'll look at what we're looking to find out, and they'll issue a legal opinion, and that, you know, may or may not be favorable to you, but I think for us to make any further determination, we may need that. I mean, I have my thoughts, but I'm just one vote, and,
okay.
You know, that's my feeling, but I'll let I know, Rick, did you have something you wanted to say?
Yeah, Mr. Chairman, when you're going to open up to the board, I'll speak.
Okay. Any other questions to the petitioner or his attorney? Okay. That closes the public hearing, and now we'll open up to the board for deliberation. Bill?
Okay, I guess I have a few things there's been an awful lot of information to go through here, so hopefully what I'm asking is in line. The first question I have is for the building commissioner. Can you just tell us again the criminal violation that was issued? What was the major reason why that was issued?
The criminal violation basically is it was an illegal change of use from our point of view. We have no records or documentation that was ever anything other than a single family.
Okay. And what brought that about?
Somehow it came to the attention for the inspector for that area. I don't know exactly what the occasion was, and he brought it to my attention. And at that point, we looked at it and we assessed it, and we sent the violation letter out to the owner.
Okay. And when you do a check like that, the counselor references in 71 the city claiming that the property was a two-family. Is there any checks with other departments when your department goes in and does a evaluation?
As a matter of fact, there is. Since I came aboard as building commissioner, one of the changes I made is that we work very, very closely with other city departments. And the assessor's office is also one. And we have an agreement that if they discovered a change of use, they're to notify our office right away. And we check it out to make sure that change of use was done legally. The only department in the city, in any city, is the building department that determines the legal use of any building within a city. And since I've done that, we've had a few calls from the assessor's office, so that when they find a change of use, they run it by us, and we verify that it was a legal or illegal change of use. The assessor's office will assess a piece of property for what it's being used as. Whether that use is legal or not is irrelevant. If it's being used as a 4-unit building and it's only a single-unit building, it will be assessed as 4 units. Then our job will be to go in and find out, how did this become 4 units? So the assessment is only an indication as to when the assessor's office actually found out. Just because they assess a building for whatever use it's being used as, that does not make the the use of that building legal. And that applies to all uses, not just residential, all uses. So the fact that the assessor picked it up in 71 is just an indication that it's been sitting there and it's been assessed for what it's being used as, whether it's legal or not. In reference to legalities, the only department in this entire city that can put a proper street number on a building is the engineering department. I've seen it multiple times because of units. Owners will label units this, that, and the other thing, put up a mailbox in front of each one. A mailman sees an envelope with something on it. He sees a mailbox, he puts it in the envelope, puts it in the mailbox. This happens all the time. But the only department in this city that can legally address a building is the engineering department. We will not issue a building permit unless we get a valid street number from them. And if that's the only address you see, then that's the only address you see, meaning the address of the subject property, which is 71 Lupine.
Right, so all city departments are recognizing the address as 71. And I understand, I know the petitioner addressed the issue about utilities with the 2 separate. That was something I was going to ask, but I'm glad it was addressed. I couldn't visually see the service. Obviously, it must be in the rear of the building, I'm assuming. I couldn't see it. But I was curious if there was 1 or 2 services in there. Now, is anything like that looked at by the building inspector when he goes in there? Does that pull any weight at all if there's service for 1 or 2? Okay.
No. You could put 20 meters on that building. That doesn't mean it's a 20-unit building.
Sure.
And technically, a second meter is not to be put on unless there's a second address, such as 71, 73, 69, 71. Otherwise, a meter should not be put on that building. And I don't believe the electrical inspector would allow it.
So was there a major violation for the usage of the property that was identified?
At some point in time, the use was changed from a doctor's office to a single-family mixed use.
No, I mean in the criminal violation. Was there one major usage that wasn't being abided by?
Basically, the illegal use was a 2-family. We only recognize it as a 1, as a single, based on the records we have in front of us.
And that's the only time, to your knowledge, that the building department inspected that property?
Yes.
Okay.
I've been told by the zoning officer back in, I think, 71, if the owners at the zoning at the time, if they wanted to come in and convert it legally to a 2-family, they could have, with the regulations in place. But no one did that. We have no record of that ever being done.
Okay. All right. Thank you. If I could ask a question of the petitioner, Mr. Bowden? Hopefully I'm saying your name correctly.
Yes. Before we do that, just procedural, I suggest we take a vote to reopen the public hearing.
I'm sorry.
Technically, it was closed.
Oh.
But it's, we can do that easily, Bill, that's not a problem. Need a motion?
Supposed to do before. Okay.
I make a motion to open the public hearing.
Second.
Roll call?
Mr. Bienvenu?
Yes.
Mr. Nguyen?
Yes.
Mr. Knox?
Yes.
Mr. Gary?
Yes.
Mr. Bailey?
Yes.
Okay, we're going to briefly reopen the public hearing for this purpose of this portion.
Thank you, Mr. Chairman. Sorry for not following procedure. Ms. Bowden, in your opinion, how many parking spaces are around your property?
I have actually had 5 vehicles in my driveway before.
And where would they be parked to total 5, sir?
I'm sorry?
the five that you claimed could be parked there, where would they be parked?
They would be parked, one in front of the garage, one behind it. Oh. Well, they would be parked, the driveway is paved from the street up to the garage.
Yep, I visited the
And that's
property.
that's a fairly long distance
Yep.
because it runs the full length of the front of the property
Mhm.
and the full length of the rear unit. So you have, as you can imagine, it's like two houses, one in front of the other. So you have quite a distance there. A car is only 8 or 9 feet long, so you can park, and I have parked 3 cars during birthday parties and so forth. 3 cars in front of the garage, and then 2 in front of the
Okay.
entrance to the rear unit.
And the 3, one being inside the garage.
No.
So you're talking 6 spaces?
Well, yeah.
A garage plus...
My garage has always been full of junk, so I've never
Okay.
been able to. My father-in-law, well, my stepfather, rather, used to park his car in the garage, but we usually don't use it for that.
Okay, so if somebody was to use the garage as a garage for a car, you're claiming you could park 6 cars there?
Yes.
Okay. Just one other question, if I can, Mr. Chairman. The discussion around the structure of the building, I know there's 2 entrances and supposed to be, is there 1 or 2 exits?
There are 2 exits.
Okay. Now, can you just briefly describe for me, I'm trying to figure out the layout in the house. When it's a 2-family, is it a separate up and down? Is there a unit down and then the second one is up, but there's a set of stairs? If you could explain the interior for me,
The
please.
front of the house is a regular,
Yep.
house. And then at the rear, on the right-hand side of that house, you have sort of a wing built out, which is a rectangular unit.
Okay.
Now, there is a front door to the front of the house. There is a side door that goes down to the basement and also accesses the front of the house. And there is a rear door that you can use to egress from the rear of the front of the unit onto a porch. That porch also has a separate doorway that provides the entrance to the rear unit. The rear unit has an upstairs and a downstairs. The front unit has an upstairs and a downstairs. Okay. The front unit has a bathroom and has a kitchen. The rear unit has a kitchen, and it has a bathroom downstairs, and it has a bathroom upstairs. So altogether, there are 3 bathrooms between the 2 houses.
Okay.
Now, as I said, there are entrances in both the front and the back, and there are cooking facilities in the front and the back, and there are bathrooms in the front and the back.
Okay. Thank you very much, sir. I guess in closing, I also believe we need a little bit of legal interpretation on the ownership and the type of building that it is. I'm at a complete loss. But I believe this is a very tough decision, and I'm glad to see the neighbors have come out and voiced their opposition. I don't mean it disrespect to the petitioner, but it's good to see the neighbors showing up, and if they're in opposition to something, it's good to get that input. But I think we do definitely need a legal opinion on the ownership, and that's all I have, Mr. Chairman. Thank you.
Okay, thanks, Bill. So the public hearing is reclosed, and I think, Rick, did you have something? Or Fezza, did you already speak? Oh, Fezza, go ahead. We'll go in order. I thought you already spoke. Jack, did you speak? No. Okay, Jack's first. I'm confused.
Through you, Mr. Chairman. I'm as confused as Mr. Bailey about a couple things. However, That being said, I think the most cogent points that were made tonight were made by the commissioner, and he answered some questions for me. The petitioner's counsel, who has done a terrific job in presenting this, and I think he was very clear in what he was looking for. That being said, the building commissioner brought some great points. Number one, the separate utilities don't necessarily indicate anything other than somebody decided to put separate utilities on the building. Separate meters, more meters. And I think specifically the commissioner said if there were 20 meters, there are 20 meters. Doesn't necessarily mean legally the building is a two-family. The other cogent point brought by the commissioner was the actual assessment doesn't necessarily indicate anything other than it was assessed. It doesn't, again, offer a legal interpretation as to whether or not it is a two-family or not. And I think those are points that I cannot overlook. I do concur with Mr. Bailey. I think we need some help, but I think the commission has brought up some valid points that would, in my own opinion, without the additional support which the city solicitor's office can offer us, would have a tendency to agree with the abutters. And again, I think what reinforced my position there is the points that the commissioner has made. I think they're valid. They can't be overlooked. I think the counselor for the petitioner references 1971, having the documentation, again, which interpreted by the commissioner, is nothing more than the assessment, but nothing prior to that. So that tells me, I guess, from 1929 to 1971, there's no documentation that validates the assessment or how it was assessed. The date 1951 is thrown around, but do we have anything, documentation that validates that? Apparently we don't. Maybe it's lost or whatever. So I'm confused. I would most definitely like this additional support of some legal advice, but I would, at this particular time, currently lead towards the abutter's position. I thank you for your time. I think the neighbors coming out is a classic example of how the system works. I think the petitioner and the council have done a great job. I think this is a very difficult decision. Thank you very much for
Thanks,
your time.
Jack. Vesna?
Thank you, Mr. Chairman. The point that the commissioner made and was brought up by Mr. Knott, those are the point that I would lean to as well, because this petitioner, or the building was built in 1929, and the permit was as a single family. Thereafter, although there was assessed in 1979 as a two-family, it's not a legal family as far as I'm concerned, because the permit was pulled as a single. Yes, the petitioner do have the opportunity then to make it a legal two-family, but did not do so. Without the help, I would concur with Mr. Knott that I tonight prepared to vote against this petition. But maybe the right things to do is to get the city solicitor opinion on this and then vote on it maybe the next hearing. But I'm prepared to do either one tonight, Mr. Chairman. Thank you.
Thanks, Vesna. And, my feeling just, looking at the application in number 2, the board members have it in front of them. The premises has been used as a two-family since 1951. I don't disagree with that. It has been taxed as a two-family since at least 1971. I don't disagree with that. And use as a two-family was consistent with the zoning ordinance in 1971. I'm not even sure I disagree with that, but I do disagree with the conclusion that it says, and therefore is a pre-existing non-conforming use. I think that's, I don't know that the proper criteria has been set. My understanding is that if there was a, and I could be wrong, but if there was a violation notice, there's, I think, pursuant to 40A 15, I think there's a 30-day appeal period. And if you don't appeal within that time, I think that the argument as to the historical use of the property becomes irrelevant. And I think at that point, this board would consider the request based on a variance, like anybody else would come before the board. And I think that's, to be honest, a very difficult task for the petitioner in this case. But I do agree with what everybody said about, getting a legal opinion from the law department. I think it would be irresponsible if we didn't at this point, and I think it would be a disservice to the petitioner if we didn't get that, because we could be wrong. But that's my feeling at this point. So that's something I would consider, but if the board decides to vote tonight, then I'm prepared to vote. Rick?
Thank you, Mr. Chairman. Through you, Mr. Chairman. Just looking at the paperwork, and obviously we've been dealing with a few of these in the city. In 1919, just for an example, Mr. Knox brought it up, at 7 and 9 Lupine Road, there was a two-family built. And that was March the 24th. Another one was built, Mary Dix, 2527. It says right here, two-family built. You go to Wallace M. Adams, in 71, it was given one address. It says, build one-family dwelling. And then Mr. Adams, I assume Mr. Adams was a doctor, like the lady said, the owner, and he put an addition on in 29 to set up shop, not to say anything different, and it was still a single-family home. He never went to change it to a two-family home. And it's always been any addition, repair, anything like that keeps coming up as a single-family. Repair the garage, repair new window, so on. What they made it into in the old days is what they made it into. It's not a legal use. As far as I'm concerned, it's a legal single-family. The proof is in the pudding right here, where everybody else on that street built duplexes. They were given two addresses, 7 and 9, 2527, 1315, 2931. When the gentleman's father bought the place, obviously it was. It probably was a single-family home, and it was obviously overly large. Whether there was a second kitchen upstairs or any other unit, I can't assume there was one if it was a doctor's office. And they blocked it up and made it into what it was. It was never picked up. It was taxed. They're taxing it again. The city taxes its use, not its legal use. They have no right to make the legal use. I think now that they're trying to sell it, I think maybe the real estate agent and being a commissioner in another town, they call us all the time. What is the legal use? They don't want to sell a bad piece of property. Because if they sell a two-family and it's a legal single, and they get caught, the next gentleman that owns it gets caught with it as a two, the lawsuits are going to fly. And that's why the probably call was made to the inspector at the time. And just looking at it the same as we looked at another one just a couple months ago. It's a single family. It was built and bought as a single family. What they made it into is a two-family. They just never got caught at it. I mean, if they came in here and they had two addresses back the same as the rest of the people on the street, I'd say there was probably a glitch. And, in 71, it was probably allowed. It was a legal use. But they never went and pulled a permit. They never did the proper things to make it legal. It's still illegal. It never makes itself legal in my eyes. It's a legal single family. I agree with you, Mr. Chairman. We probably should get an opinion from the law department, if that's what the rest of the panel wants to do. I have no problem with that. But as I look at it, it's a single-family home. That's how it was built. That's how it was maintained. They made it into a two for extended family, for extended reasons. A gentleman in the neighborhood lived in it. I mean, it was an illegal use. People think things are legal when they look at them. It's my opinion. It's a single family and a single family only. And that's all they're entitled to is a single family. That's all, Mr. Chairman.
Thanks, Rick. Okay, what is the wish of the board?
Mr. Chairman, I recommend that we move this to the city solicitor and get their opinion and then come back and make a decision.
Okay, so I'd entertain a motion to refer this application to the city solicitor's office for a legal opinion and have the matter addressed at the October 27th hearing, Counsel, if that's convenient to you. And we'll certainly provide you with a copy of his opinion in advance of that, so you can review it. Well, I think we do have to make that clear. So I think what I would vote on would be a request that we submit this application and the attendant documents to the law department, City Law Department, for a legal opinion as to the legal status of the unit, of that house, and whether or not we as a board can establish its legal use as a two-family. And any other, whatever other opinion, we would not be limited to, if their opinion goes beyond what we've asked, we're not going to limit, just so you know, we're not going to limit our decision just based on the answers to those questions. We'll take the opinion in its entirety, and, you know, you'll also have advanced copy of that as well for the meeting. Mr. Camacho.
I have a question for the attorney, and just for clarification. Is it your position that the original document, the application for a permit, it stated a single, and that should have stated a two?
No, I have no basis to suggest that they meant to say two, but my position is in 71, it became a permitted use. At that point, it is by definition legal because it is a permitted use as of right in the zone. They don't have to do anything else in 71. It's a permitted use as of right. They become legal in 71 because it's a permitted use.
That will be a specific question that we will ask the law department.
Exactly. That I would, the question that the city solicitor should have is, back in 71, even though it may be by right, and if they qualified, were they required to petition the Zoning Board of Appeals to convert that legally to a two-family? The other question I would ask the attorney to address is the word grandfather, which I haven't heard that spoken yet. And to the best of my knowledge and my training, I've been told that grandfathering means that a property was built under the when a property was built and it met all the regulations at the time, it was legal. And if the zoning regulations changed, it was grandfathered in, because when it was built, it met dimensional requirements and use requirements, etc. I have not heard that word used at all today.
Right, I don't think this is a suggestion that's grandfathered, no.
Well, I guess the problem I have is if it was grandfathered in, we maybe not be having this discussion. I'd like to see the city attorney address that part of it. That concerns me a little bit, because if it was grandfathered in and the zoning has changed over the years, and when it was built back in 1921, if it met all the requirements then it's automatically grandfathered in and it can maintain whatever it was at that time.
I agree.
And the other problem I have is I'm struggling with, and I'm concerned about, is I'm hearing mixed testimony. Once that it was built as a two-family, but then I see that later on the testimony stated that a doctor owned it originally, lived in the front, used the back as an office, and then at some other time, a wall was put up to divide the two sections. So that tells me that, on one hand, and correct me if I'm wrong, on one hand, that originally it was a two-family, and then later on I heard testimony that it was a doctor's office and originally a mixed use, an office and a house, and then converted, when the wall was put up, converted to a two-family. That confuses me. So a couple of things I think the attorney, the city solicitor, I think would like to have them address.
Okay. Right, and I think we can structure it so we can, if we say to refer the matter for a legal opinion as to the current legal status of this property and addressing the 1971, the zoning in 1971, because that was in effect, does that automatically convert this property to a legal two-family? Or do they have to take some affirmative action
and come to this board? Correct.
And come to this board. Okay? All right, so that's,
excuse me, Mr.
I'll
Chairman.
entertain, if somebody wants to, I can't, as a chairman, I cannot.
Before you go on, there's one other item. that concerns me is the plot plan, although it may be stamped and certified, it's showing spaces for parking, but technically that plan isn't acceptable because it's not showing the number of vehicles that could be placed in those spots. And that's something that the surveyor should have put on there, the civil engineer.
Yeah, and I mean, to be fair, if you want to correct that, prior to, we could submit that to the, legal law department as well, if you wanted, if that's just an oversight. I don't want you to be penalized if it's just a mere oversight on the architect or the drafter's side. I'm not going to penalize you. I don't think we'd penalize you for that, but I agree, it does need to be, is it stacked parking? Is it, we need to know where the parking is. So we'll give you a chance to correct that and just get it to the Kim at the zoning board as soon as possible. And so we need a motion.
Motion to refer to city solicitor for opinions.
Need a second?
Second.
Roll call, please, Stephanie. He doesn't. I'm sorry.
Continue.
Refer to the city solicitor office.
Refer to city solicitor and continue. Thank you.
Refer to city solicitor's office and continue to October 27th. And there'll be no further public notice of that.
Mr. Chairman?
Mr. Chairman, may I ask you to make it perfectly clear to the neighbors what the process is right now, since this is new to them?
I will do that right after the vote.
Thank you kindly.
Thank you.
Refer to the city solicitor and continue.
Mr. Chairman? I won't be here on the 27th.
Okay.
I don't know if it matters or not.
Okay, and before we conclude, I was just informed by Mr. Bienvenu that he will not be here on the 27th. Nobody who was here prior to this, the two members that aren't here, cannot vote on it. So on that day, you would need a unanimous vote, all 4 votes, 4 of us, presuming everybody's here that day, or you'd get a continuance. That would be your choice that day. And yes, that would be. That might give you a little more time anyway. We might need it. So when is the next date? November 10th. Okay. Any board member that's here right now expecting not to be here on November 10th? Okay. So if we could take another roll call. Stephanie, same motion. Continue to November 10th.
Continue to November 10th.
Continue to November 10th.
Refer to city solicitor and continue to November 10th.
Refer and continue to November 10th.
Refer and continue to November 10th.
Okay, the petition, just so everybody knows, it's been continued to November 10th. In between now and then, certain questions will be written and sent up to the city solicitor's office for their legal opinion. This board will probably most likely rely completely on the opinion of the law department as to the relevant legal issues here. We'll also provide a copy of that to council, and there will be no further public notice, so anybody wishing to come to the meeting can come on November 10th. The public hearing is closed. The public hearing will not be reopened unless there's a vote to do so, so we're not going to hear any new issues unless the opinion from the law department gives us an opinion that opens up a new area that has not been discussed. If that happens at that point, the board will vote whether or not to open up the public hearing. Okay, so that matter will be continued to November 10th. Thank you very much for coming. Water department. Yeah.
doing that.
Vesna.
Bob, how you doing? Can we see?
Good to see you. I'm Jim.
Tell them what we want. We said we agree with whatever we want to do. It's great. Can't wait to go have dinner over there. Let's open it up. How soon can we get it opened?
Okay, we're going to start the meeting again. We're going to pick up at the second to last petition tonight. That's ZB 2008-38. That's a variance for Zenwan Lee and Ian Zhao, Lee, if I'm pronouncing that properly. 101 Lakeview Ave. This is a urban mixed-use district. This is a petition to vary the parking requirements for a proposed restaurant according to section 6.1 of the zone ordinance and off-street parking regulations. Attorney Tagg?
Good afternoon, good evening, Mr. Chairman. It's a little bit later than this afternoon. And hopefully the board will share my opinion that our item is somewhat less controversial than those that you've dealt with tonight. As usual, let me begin by personally thanking each of you for your time and your service to the city. I'd like to acknowledge Mr. Camacho and Ms. Murphy at the building department and the other members of the building department as well for shepherding us through this. You know, I'm a guy that requires a lot of patience, and they've certainly given me that. And they always treated me with dignity, even though I don't think I always deserve to be treated with a...
Don't be so hard on yourself.
Before you tonight is a variance application of Mr. and Mrs. Zhenwan Lee, and rather than run the risk of mangling his name, I'll call him Jimmy, which he's known as around the neighborhood. They're the owners of the property at 101 Lakeview Ave. This is the site of the former Dawn's Radio and TV, and as each of you are aware, the building on the site has been in disrepair for a long, long time. I firmly believe that its condition and the condition, other conditions extant in Lower Centerville has inhibited economic growth and pleasant living conditions for the property owners and residents alike. Recently, the neighborhood has had an infusion of private investment that promises to change the character of Lower Centerville, and the Lees project is one more step in promoting that forward-looking, beneficial trend. For the purpose of our being before you is because the Lees intend to open and operate a Chinese restaurant on the site. Heretofore, they've successfully operated the Gold Star restaurant on Fairmount Street in the Belvedere section for more than a decade. I dare say at least one of you has probably patronized their establishment on Fairmount Street at one point or another. I have. The food is good. The owners are charming and hardworking. This is the longest I've ever seen Jimmy Lee take a break, by the way, tonight. But they're hardworking, they have strong customer loyalty, and they're a quality addition to our neighborhood. The Lees are looking to bring that record of success that they've enjoyed over at Gold Star on Fairmount Street to the Lower Centerville area with a twist. They want to open the new restaurant with a dining room feature for eat-in customers. The letter of the zoning code would require us to provide off-street parking, one space for every 100 square feet of interior building space. And the Lees plan seeks relief from strict adherence to the letter of the code. By the code, we would need 23 parking spaces, but we think that strict adherence to the letter of the code is illogical to apply in all cases, and especially, across the board in all cases, but especially in this one. It makes more sense, doesn't it, to measure a restaurant's parking space requirement from the square footage of the actual dining area, because that's the area of the restaurant that's actually going to be generating the automobiles that will fill those parking spaces. In the Lee's case, the actual dining area would be approximately 1,370 square feet, which, applying the logic that only dining-related square footage of the building be counted toward the parking requirement, would mean that they would only need 14 parking spaces. Our plan manages 12 parking spaces. So applying the aforementioned logic, what we'd be looking for is a relief on 2 parking spaces. The dimensional requirements of the zoning code were written for all restaurants in the city, and I think you can draw on your personal experience to tell you that there's a difference between the way patrons consume their meals at Chinese restaurants as opposed to Italian, French, or Greek restaurants, or many other types of restaurants. Only occasionally, it is my experience, do Chinese restaurant patrons not take their food home for consumption, while the Italian, Portuguese, French, and Greek restaurant patrons virtually always stay on the site for the consumption of their meals. I may be leaving out other ethnic groups that are similar to the Chinese restaurant or to the other mentioned examples, but my purpose is not to create an exhaustive list, only to point out that there's an inconsistency in similarly applying the parking requirement under the code to all restaurants, while their customer eating habits may be quite dissimilar. That's the very reason for a zoning board of appeals, isn't it? Because the circumstances may arise or they may exist that the authors of the code never contemplated. So we ask for you, in rendering your decision, to consider the following. The Lees are citizens of our city. They have a track record of success, meaning this is not an experiment, but a growth of a going concern. They're investing a huge amount of private capital in a formerly depressed area of the city at a time when private capital is in high demand and short supply. They're replacing a decrepit eyesore with an aesthetically pleasing eating establishment that, because of its marvelous appearance, may inspire others in the neighborhood to upgrade their own properties. It brings the option to dine out in close proximity to the population of Lower Centerville, a population that always has had to travel to dine out before. It brings lighting, beauty, safety, and vitality to elevate the stature of Lower Centerville. The benefits to the community are enormous, and we urge your approval. And with that, I'll take any questions or comments you may have.
Thanks. And so if I understood you, the dining area, the square footage of the whole place wouldn't really be a fair assessment of what parking you need because the dining room's significantly smaller, is that what you're saying?
The kitchen takes up a considerable amount of the site itself. The only area that is allocated toward the dining room is 1,370 square feet, I believe, on the
And how many spots would you need
draft.
if that were the case? Or
We
just-
would have needed 14, and we provided for 12.
Okay. That's the only question I had. Okay, is anybody here wish to speak in favor of this petition? Please address the board. State your name and address, ma'am.
Hi, I'm Pat Hunt. I'm the Vice President of Centerville Neighborhood Action Group, and I live at 205 North Llewellyn Street in Lowell. I approve this. I think it's a great idea. It does bring in new progress in that part of the city, which has been under pretty deplorable conditions for many years, and that building has been vacant for well over 8 years. And with the new CVS store down the street, which is really coming along quite nicely, and then this new establishment, we just feel that it's a benefit for the neighborhood to build up the character. It's great for the neighbors, for those people who do not travel in vehicles, they can certainly walk and go and have dinner down there. So we're really excited about it, and we hope that you do approve it. Thank you.
Thank you, ma'am. Anybody else wish to speak in favor of this petition?
My name is Anne Marie Page. I live at 26 Fremont Street, Lowell, and I'm the president of the Centerville Neighborhood Action Group. We are quite pleased that Mr. Lee has chosen Centerville to bring his business. And we are very happy to see another empty building gone. There are too many of them throughout the city, and there's way too many of them in Centerville. And we're very happy. We're not worried about this parking because the only thing in Centerville that has more than 12 parking spots, I think, is Stewart 24 and Demoulas. Other than that, there's not much land free in Centerville. So he is utilizing it very, very well. And quite a bit of his service is takeout, but he is also setting up a small dining room. And it's a family restaurant. So there's not going to be liquor and wild parties and noisy to the neighbors. So it's good. All of it is good. They have met with us. We have looked at the pictures, looked at the drawings. We've looked at the signage. We're very pleased, and we are very comfortable that Mr. Lee will be a good neighbor. He understands we do like lights, we do like plants, and we love it when somebody knows how to use a broom. So we're very happy to see Mr. Lee coming to Centerville, and we're certainly hoping you're going to be able to help him. Thank you very much, gentlemen. It's been a long night.
Thank you, Ms. Page. Anybody else wish to speak in favor? Hearing none, that portion of the public hearing is closed. Anybody wish to speak in opposition? In opposition, hearing none, that portion of the public hearing is closed, and now we'll open up to the board. Bill?
Thank you, Mr. Chairman. Council, you mentioned 12, you're providing 12 parking spaces?
That's correct. There are 11 along the extreme end of the property and 1 next to the building.
Okay, maybe, oh, okay, I got it. Is that, is the 12th one, is that for handicap parking or not?
Yes.
So there'll be 1 spot for handicap?
There'll be 1 spot for handicap parking.
Okay. When I drove by the facility, I guess as you're looking into the parking area, so he'll be taking everything on the right-hand side where, is there currently some parking going on there that says private parking or private area?
The property was owned by the same person. The abutting property was owned by the same person, so he had historically taken to letting his tenants park on the site. We did provide sufficient, there will be sufficient driveway room for him to get a driveway back to his parking lot, which is actually behind his building on the right-hand side.
Well, I would also assume that where the location of the facility is going to be, probably have some foot traffic, customers coming from the neighborhoods.
We hope so.
Walking and not having to park, which would probably be a good thing for the neighborhood anyways with less. And I think that even parking on the street, there seems to be sufficient parking on the street. That Lakeview is a wide enough road. I don't see any issues there either. So I firmly endorse the petitioner, and I wish him the best of luck with his venture there.
Thanks,
Thank you.
Bill. Jack?
Through you, Mr. Chairman. Hours of operation.
The hours of operation, it won't conflict with the, we thought about that, and it will basically be started around 11, and it will carry through to 11 o'clock at night, or...
Anticipated signage?
We are anticipating flat signs along the side of the building illuminated by floodlights or hook lights back toward the building, but nothing, none of the flashy lights that Centerville has come to know.
I agree with my fellow board member, with Mr. Bailey. This will complement the CVS project tremendously. That particular end of the street, Don's Radio, and that building has been abandoned for I don't know how many years. And to see that, and this gentleman, Jimmy Lee, willing to come in and make the commitment simultaneously with CVS is going to do nothing but enhance that whole entryway, across the bridge, and off the VFW highway into Centerville. I think it's a tremendous asset. I wish you tremendous success, and I totally support the petition.
Thanks, Jack. Vesna?
Thank you, sir. Council, in the application, you indicated that 80% of the business is takeout, and the other 20 will be a sit-in type of family dine-in. How many tables is this going to be in the facility?
The current draft on the elevations of the interior calls for 10 tables, 9 square tables and one large round table. We haven't really completed what the interior of the building is ultimately going to be like. We needed to come jump this hurdle first. But we're looking for somewhere around 10 tables, and the 20% takeout was just an estimate based on what we believe in talking to other Chinese restaurant operators they've experienced.
You mean the 80% takeout?
Did I say 80% takeout? Yes.
You said 10 table. How many chair per table, though?
Jimmy, can you speak to that? How many chairs per table? How many chairs per table? Is it 8? I think there are 8 per table.
I didn't see that plan.
Yeah, 8 per table. That would be 8 per table, Mr.
All right.
Nolan.
This surely is a very ambitious project, because assuming that Mr. Lee is successful, you're going to have down the road issue with parking. With that being said, I do support as now that there's a need to really bring some business to that area. But I hope that, that at some point, Mr. Lee and other people, community organizer like Ms. Page, address the issue of parking, because when you have 10 tables, you have 8 chairs per table, assuming that it's a full capacity, you're going to have some issue with parking. But with that being said, I just forewarn it, I too in support of this petition.
Thanks, Vesna. Rick?
Through you, Mr. Chairman. Question I have is, the piece of land that's out back behind the hedgerow that you have, the privacy?
Yes.
Does that belong to this parcel of land too? Is it all together?
That's not zoned in the UMU zone. That is zoned in the residential zone. That particular area of the property is going to be a contemplative garden area that is it's going to be buffered by trees, and and the patrons will be able to, you know, take a walk back there. And
So it's gonna be something, Anne Marie, out there, nice garden and stuff, that's what you're looking for?
Yes.
Okay. No, I was just,
maybe some Chinese pear trees or.
I had the same concerns about the parking and the number of people and stuff. I am for it because we need to bring some business over there and start getting some empty buildings filled. I would be for it if we could have probably a one-year review. That way, the Centerville Action Group could come back into us and say, it's working out great, or we need to find a little bit more parking, or we need to cut down on the seats in there, maybe we go to half or whatever. But I want to see the gentleman have a good shot over there, do business.
Okay,
I'm for it if we could do that, Mr. Chairman.
Thanks, Rick. And Vesna wanted to readdress.
Thank you, Mr. Chairman. Did I hear that, Mr. Lee, you own a Chinese places on the Belvedere area? How many tables you have there, sir? 20 table, right? 26, okay. How many parking you have over there? Big, yeah. Right. Well, if I see. Well, good luck, sir. Thank you, Mr. Chairman.
Thanks. Okay, need a motion?
I'm sorry, I don't have my glasses tonight, and it's only 4 to a table, except for the great round table in which there's 8. So there are 9 tables of 4 and 1 table
So
of 8.
there's four chair per table. Council, you're going to get a pay cut tonight.
Say that, Mr.
I like Mr. Balview's recommendations that maybe would also help us too in the neighborhood associations. That I would make a motion to approve with conditions that come back in 1 year just for review.
Okay, need a second?
Mr. Chairman,
Go ahead.
Mr. Commissioner.
Just a word on the occupancy load. I mean, originally, it was coming in at approximately 90, but at 4 per table, with only 1 or 2 tables carrying more than that, you're actually looking at a load of about half that.
Thank you, sir.
Which would obviously have an impact on the parking.
Thank you. Thank you, Mr. Chairman.
Okay, need a motion?
I make a motion to approve with conditions that the petitioner come back for review in 1 year, and just to see how it goes. Thank you.
Seconded.
Okay, need roll call? Stephanie?
Approve with conditions.
Approve with condition.
Approved with conditions.
Approve with condition?
Approved with condition.
Okay, Attorney Tagg, if you could come up and just sign this plan anywhere and hand it to Stephanie, appreciate it. Been approved unanimously with 5 votes. Dennis, just watch your step on that wire. All right. Okay. Our final petition tonight, and we apologize, folks, for the long night, but ZB 2008-40, this is a special permit and variance request. The applicant is Edward Ray. The address is 10 Concord Street, otherwise known as, or also known as 12 Concord Street, an urban mixed-use zone to allow body art establishment and the same within 500 feet of a residential zoning district according to sections 731 and 7312 of the zoning ordinance. Welcome, sir. What would you like to say?
Yeah, thank you for having me, obviously. The reason why I went after this building over there is because it's kind of set up pretty close to what I was looking for. It was a barber shop at one time, and everything is in there that I need. Sinks, the walls, the partitions. It just needs a little bit of elbow grease and probably some paint. And so I filled out the application, and this is where I stand right now.
Okay. And can you tell us a little bit about the business you propose to use there?
Yep, it's a tattoo shop. I've opened one up here in Lowell previously. Had no problems with it whatsoever. Also had one in North Chelmsford and closed that one for the Lowell shop, and I want to open up another location.
Okay, do these require anything from the Board of Health?
Absolutely.
Okay.
Absolutely.
And do you get those, if you get approvals here, do you then get those, or do you?
Correct. What I'll do is, if the permits and the variants go through here this evening, I'll continue on with Donna Cox over at the Health Department.
Mhm.
They've been informed of what I'm doing, and I'll have them come do a walkthrough to make sure that everything is up to par, and any changes that I need to make, obviously, will get done.
Okay. Is there anything, can you tell us a little bit about what you expect for clientele, like how many people, or is it your hours of operation?
Absolutely. The hours of operation would be Tuesday through Saturday, 12 in the afternoon until 8 p.m. No Sundays, no Mondays. Clientele strictly by appointment only. And that, even like the parking situation over there, which was kind of a concern with myself. Jay Barczyk, the gentleman that owns the building, been pretty fair with me on that. As for parking, I have access to, obviously there's 2 spots in front of the location, which I think is more than enough.
Okay, and how many employees we have there?
There'll be myself and Jennifer, which will be running the counter.
Just the 2 of you?
Correct.
And will you both be there at the same time all the time?
Absolutely.
Or will it just be one or the other? Or?
Nope, absolutely. Both of us there at all times.
Okay. All right, would you like to say anything else, sir?
Excuse me?
Is there anything else you'd like to say?
No, sir, I think that's pretty much it. I just, I really appreciate your time. I really
Okay.
do, and I know it's getting a little late, and, I thank you for having me.
All right, just stay up there for a minute. I'm just going to do the procedure. Is anybody here wishing to speak in favor of this petition? In favor? Hearing none, I assume you are, but hearing none, that portion of the public hearing is closed. Anybody here wishing to speak in opposition? In opposition, and hearing none, that portion of the public hearing is closed. And sir, while you're up there, before I close the public hearing, I will ask the board members if they have any questions of you.
Absolutely.
Start with Bill.
Thank you, Mr. Chairman. Mr. Reyes,
Yes, sir.
Wayne Burbine,
Yes,
who
sir.
may that be?
Wayne Burbine is my partner in the shop. I took a business partner in. He cannot be here tonight. He fell off a ladder and is in serious back problem.
Yep.
He is actually in the hospital. He's been in the hospital for almost 2 weeks. He broke his lower back.
Is Mr. Burbine going to be an employee there?
He'll be employed there mostly as just as an advisor on, just the finance part of it, but for the physical being on the shop, it'll be pretty much strictly myself and Jennifer. Jennifer would be running the counter.
Okay.
He's actually funding the shop.
So you'll be the only 2 licensed?
Nope, I'll be the only licensed tattoo person in that
Okay.
building. Will be myself.
Okay.
There'll be, Jennifer strictly does
Yep.
just dealing with the customers for appointments. No
Okay.
tattooing whatsoever.
Now, you submitted a permit to operate a body art facility?
No, sir, I cannot follow through with that until I have the permit from here first. Then I can go to the
Right.
to the health
I mean, it
department.
expired in 2004.
Yeah, no,
That's-
I put that in the package just to, to understand that this is what I do for a living.
Okay. What are your plans for a disposal area, for a dumpster, for instance?
I have a container coming from either National Waste Management or Medical Waste Disposable Company, and they provide the whole thing. It's a sealed unit, it's...
Where will that be located, sir?
That'd be located behind the counter, away from the general public, absolutely.
So it'll be inside the facility?
Correct.
Okay.
It's a 20-gallon container.
Right.
And it's disposed of every week.
Yep. The only other thing I would add, Mr. Chairman, I think we should have a condition that the Board of Health approves Mr. Ray's venture here, and without that approval, then,
Conditioned upon approval of the Board of Health?
Yes.
Yeah,
Yep.
that sounds good.
Yep. Thank you, Mr. Chairman.
Hey, Jack?
I agree with the condition Mr. Bailey just proposed. This is another particular building that vacant, former barber shop, as you alluded to. And with the history that Mr. Reyes has with 2 other businesses, and particularly are you going to operate the other one in Lowell as well? You mentioned
No, sir,
another
the one in Lowell, that's run by Chucky Diamond. He has that shop.
Okay.
and I'll be running this one over here.
Okay. And since the petitioner has had no other problems or issues, certainly by this particular point, the commissioner or others would have heard of it, then I would approve it, and based upon the condition that they obtain the proper permits from the Board of Health. Thank you.
I have a question for you, sir, if you don't
Yes.
mind. With the condition of the approval from the Health Department, I don't know, I'm just trying to kind of like mentally figure out what Donna Cox might ask for. Do I need to have her get a hold of anybody here personally, or how would that work, so that you know what's going on also?
I believe what would happen is we would vote and give you permission.
Okay.
If you are denied, we would rescind it. Is that correct, Mr. Chairman?
Yeah, if you're denied, then our approval would be conditioned upon that approval. So
All right,
without that approval, there would be no approval from this board.
I understand what you're saying. Okay, yep.
Well, isn't the process that you have to get the approval here first, and then you go to the Board of Health?
Correct. Yep.
Okay.
That's the way that the Board of Health has it written up. I have to get the approval from,
Right,
from the
so
zoning board.
so the Health Department will receive our, recommendation here, and then it'll go forward.
Okay.
And you couldn't pull the permit for it anyway without the Board of Health, right, Bob?
No, I have to, I have to have, but they both have to work together.
Through you, Chairman, the question I have is, when the Board of Health issues you a permit to operate, do they go down and inspect the facility?
Absolutely, yep.
Then I think the process here would be simple. He would come to us for a building permit to do whatever fit-up is necessary, minor conversions, and technically a change of use. When his operation is up and running, and he's got everything in place, then the Board of Health would come down and verify that whatever their requirements are in place, and at that point, they would give you the permit to go ahead, correct?
The permit to operate, correct.
Okay.
Yeah, so this would be the first step. He will do some preliminary talking with the Board of Health, Donna Cox. Come to our department for whatever permit is needed to do any minor work inside or in a change of use. When that's completed and we're satisfied, and he's ready to go, the Board of Health will go down and check the facility out, and at that point, issue the permit for him to operate.
Okay, thank you. Okay, Besna?
Well, Mr. Chairman, given the fact that our board members, Mr. Bailey is a former Board of Health Commissioners, I defer this to him, and I heard his support of this petition, pending that the approval from the Board of Health. I too in support of this petition.
Okay, thank you, Besna. Rick?
Evening, Mr. Ray, how you doing?
Very good, sir. How are you this
Good,
evening?
thanks. This will be the same as on Worthing Street, correct?
Excuse me?
This operation will be the same as on Worthing Street?
It'll be run identical the way it is over there. The only thing I will have that they use over there that I won't is they do body piercing. I do no body piercing.
You'll do
It'll be
no-
strictly tattooing.
Strictly tattoos?
Correct.
I'll be in favor of setting,
Okay, so I think procedurally, what we have to do is take the first vote for the special permit, and then a second vote for the variance to allow it. So I'll entertain a motion for a special permit for the body art establishment.
Second.
I can't make the motion, so we're all tired. I don't even know what I just said, so.
I was just going to ask you to repeat it.
So I'll entertain a motion.
Entertain a motion to approve the variance,
The special permit first.
special permit first.
Okay, need a second?
I second the motion.
Roll call?
approve.
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 Approve with the condition of the approval of the Board of Health. It's kind of redundant, but we did say it, so.
That's what I was going to ask. Approve with condition.
Okay. I'd entertain another motion for a variance to locate it within 500 feet of a residential zoning district.
I make a motion to approve the variant with conditions of the approval from the Board of Health.
Okay, need a second?
Second.
Roll call, please, Stephanie?
Approve with conditions?
Approve with condition.
Approve with conditions.
Approve with conditions?
Approved with conditions.
Sir, you've been unanimously approved. Just make sure you deal with the Board of Health. And I think you know that you can talk to the zoning department about the appeal period. Okay, thank you very much.
Have a good evening. Gentlemen, thank you for your
Yeah.
time.
Sir, I do need you to sign something.
Oh, okay.
I don't know, that's why I just, you know what, I think you're all set. You're all set, sir. We don't have a plan. We don't have a plan, though, right?
No.
Oh, no, we do. We do, I'm sorry.
Right here, this one?
Yeah. If you could just initial that and hand that to Stephanie.
Thank you very much.
Thank you, sir. Good luck. Okay, the other businesses, everybody's had a chance to review the minutes of August 25th, September 8th,
Thank you.
and September 22nd. Anybody have any questions as to those minutes? Okay, all in favor of approving the minutes from August 25th, September 8th, and September 22nd, say aye.
Aye.
Aye, sir.
So all in favor, so those minutes have been approved, and
Thank you.
thank you. At this point, I'd consider a motion to adjourn. And this second,
Seconded, sir.
all in favor, say aye.
Aye.
Aye, sir.
Meeting adjourned. Thank you.